of your lordship's determination, I want to move it on 28th, before the vacation bench. Well, there is an urgency because no confidence motion has been summoned.
Mentioned before the vacation bench.
No,
Why are you
leave
mentioning
has to be granted by your lordship.
No, leave will be granted by the vacation bench.
No, my lord, according to the notification, first day vacation, my lord, it has been indicated that the matter will be moved. If you want to move,
Show me what is it.
Notification.
Oh no.
Yes, my lord. If you
What is this case? What is the case? Tell me.
The case is, my lord, no confidence motion, my lord, of the municipality.
Yeah.
We are the requisitionists. Now, my lord, fixing within 30 days, it has to be summoned. Now, within 15 days, my lord, DM issued a memorandum dissolving the entire board. What cannot be done in
which municipality?
My lord, Raghunathpur Purulia municipality, my lord. That cannot be done in the eye of law because, my lord, once 18.3 has been invoked, my lord, there has to be an issuance of no confidence motion. Date has to be fixed. My lord, that has not been done. Ultimately, my lord, the democracy will prevail. Now, my lord, the entire voting system will go. Has been done, my lord, by the strength of this order passed by the DM, my lord, last annexure. And the principal secretary, no, my lord, there are private respondents. My lord, principal secretary already, my lord, issued a memorandum, my lord, appointing the SDO as an arbitrator, administrator. Last memorandum, my lord, on day before yesterday, my lord, I subject to your lordship's kind sanction, it has been issued. But as there are private respondents, for such reason, my lord, I have come before your lordship that it has to be moved because they have to be served. Or I can move at 2 p.m. my lord, if your lordship so desire. Last annexure. And P1, my lord, the requisitionists, my lord, they have submitted their requisition for no confidence. That has been avoided. Invoking 243J. But 243J is there are irregularities.
All right, let it be listed.
I'm grateful.
May I have your lordship leave to mention there is extreme urgency in the matter. Petitioner is right now in the Bahrain. He is in my lord the HRA of a my lord multinational company. He is my lord the visa is going to expire on the my lord 25th of May 2025. Since my lord the passport is going to be my lord expire on 25th of June 2025. So, my lord, despite my lord making an application in the month of January 2025, that my lord the visa, my lord the passport has not yet been renewed. Yesterday or day before yesterday, we have got an intimation that my lord police clearance has not been given. No, my lord, the reasoning has been given as to why police clearance is not there. So I am not here, my lord, to pursue the matter. No information has not been given.
Nothing doing, sir.
May I have my lord?
Only the thing is this, my lord. Only the thing is this. Kindly post the matter tomorrow because it is in the days list.
Not posting it tomorrow, sir.
So in that event, my lord, kindly give me the leave so that the matter can be done.
I'm not giving any leave. Go and mention before the vacation bench. Yes. Yes.
For leave to file applications without certified copy, lordship.
You have the server copy?
The applicant applied for the certified copy, lordship.
Madam, do you have the server copy?
Yes, lordship.
What is this petition?
The present petition is the tenant, lordship. Suddenly he received a notice for demolition, lordship, from Kolkata Municipal Corporation. Finally, leave to file.
Show me the server copy. What are you challenging?
Petitioner, the tenant since 30 years.
Are you challenging this order? This has to go before the division bench.
That's why I was.
Oh, this has to go. Sorry, madam.
My lord, considering the urgency of the matter, Justice Sinha granted us the leave. Today is the item number is 12 of the Justice Sinha's list.
Sir,
kindly appreciate the difficulty, my lord. Otherwise, I would be jobless, my lord. Kindly
I
appreciate
have
the
appreciated your difficulty, sir. I have heard you and I have rejected your prayer. Okay.
May I have my lord's leave to mention a matter from the determination of Justice Sinha, my lord.
Yes.
Item 7, my lord, it was posted as item 7 as urgent motion.
Yes.
The difficulty is that if today the matter is not taken up, I have got notice from the railway authorities that they will they'll issue me notice to vacate this stall, my lord. These sorts of these sorts of matters, my lord, there has been a consistent order which has been passed by Justice Sinha. I will only seek for representation to be considered by the divisional commissioner, divisional manager, which has been the consistent
Madam,
order.
I'm not passing any orders as far as these unauthorized occupants sitting on government land are concerned. All right, you take it before the appropriate bench.
The bench is not available till the vacation. My writ will become infructuous.
You move it before the vacation bench.
The writ will become infructuous
It
by
will
the
not
time.
become infructuous. Nothing is being done in these cases. I know it.
I have got a notice
They
yesterday.
keep giving notices, nothing happens.
But it has happened. I am AH wheeler. Numerous of my stores in
Madam,
Asansol and everywhere.
When was the
have been-
notice issued?
The notice issued to me
Yes.
just yesterday night.
What is the notice?
The notice
You reply
is-
to the notice. What is the notice?
This notice says that they will demolish. That I'm directed to remove my stalls by 74
No, all
hours.
illegal encroachers, nothing else.
No,
They
Milord.
follow the
Yes,
process.
under contract, Milord. It is
Nothing,
not illegal, Milord.
nothing,
But I am H wheeler. I have been running stalls since
nothing
many,
doing.
many
I
years.
can't help you, madam.
But
Sorry.
they will kindly consider.
No,
Milord.
madam, I
Become
can't help
infructuous, Milord.
I can't help you,
running in
madam.
the list.
I can't help you. Yes.
But may I mention a matter pertaining to
Yes.
your lordship's determination, my lord? Yesterday night, a notice has been affixed saying that they will start demolition today. The
Yes.
demolition order has not been served upon us at all. If they come and show your lordship the demolition order, I shall go out. But it is an original site. My lord, if it may appear in a special list, my lord, at 2 p.m., my lord, they are going
Today
to
I can't, Mr. Sen. Today I have a division bench, and then after that,
at 1 o'clock anytime convenient to your lordship. Because my lord, the notice
My lord-
says today they will start.
have you served them?
But I shall immediately, after obtaining leave, my lord, I shall serve them immediately and come back, my lord.
Serve them, and
Anytime whenever your lordship finds it convenient, I shall just get the leave of your lordship and serve them.
no demolition order has been issued to you.
Has been served upon me.
You have participated in the hearing,
Yes, I have participated in the hearing, my lord.
so you know that there is an authorized construction.
No, but they have not passed the order. I have said, my lord, that there is a sanction plan. If there are minor irregularity, that they can regularize. But they have to serve a formal order.
They have not given any demolition order.
No, my lord.
What is this which you're challenging?
Well, this is the notice which they have affixed. They were saying that they will implement an order and they will start demolition.
Or put it today.
My lord, may I permitted to mention one matter, my lord?
Ask it.
That
So 2 o'clock I have a division bench now. Keep it at 3 o'clock.
1 o'clock if it is commenced,
3 o'clock.
3 o'clock.
Serve them notice.
I shall.
Which municipality is this?
Yes, I shall.
Which municipality? Calcutta?
Calcutta. Well, Calcutta.
उससे पहले ले 245 245
Oh,
Mr.
right.
Sen, 245
My lord, may I permitted to mention one matter? This is with regard to, my lord, the extension of interim order, my lord. This is going to expire on 3rd June, my lord.
which bench? My bench?
Yes, my lord.
3rd of June.
3rd June.
My lord, I'm paying for.
And when were you given the order, madam?
Yes, my lord.
When was the order given?
Um,
Why do you come at the last
my lord,
minute?
my lord, there was a specific order.
When was the order, interim order granted to you?
My lord, there was an extension for 3 months. They have stated for 3rd April, my lord.
So the last day you
3rd
wake up,
April, my lord.
last working day, you remember that you need extension. Take it tomorrow.
My lord,
May I
I'm
be
praying-
permitted to mention a matter relating to IOCL? This is a tender matter. I am the successful bidder,
Good.
but somehow another preferred bidder is being given a chance, but not me. My trucks have been taken. They have been accepted, but only all 5 have been taken, but only for 3 slots. The rest have been given to the preferred bidder.
Nothing doing.
Lordship, the work
Next.
order is going to
Nothing
be
doing,
issued.
sir. Sorry, nothing.
If you move one IA to travel abroad, my lord, the main proceeding has been stayed by this honorable court, my lord, by Justice Sinha.
It's very hot abroad. Don't travel this time.
Well, may we permit? File can, my lord. I have filed the can, my lord. 24th is the date to travel.
Mr.
my lord.
Bhattacharya, sorry.
Well, and maybe permit to
Yes.
mention, my lord, on the urgency is that, my lord, from your lordship's determination.
Yes.
twice I have mentioned. Urgency is that
Yes.
a demand was raised upon the petitioner on the ground. We are holding only 1,000 square feet. Now the demand G+3 story building demand is imposed upon me.
Demand is there. Go to the tribunal. Why don't you go to the
What
tribunal?
has happened? No assessment, no inspection, nothing has been done. And within 7 days, we have to pay the entire amount.
Demand has
We are-
been issued without any assessment.
Yes. And kindly see, within a 7 days, we have to pay. We are apprehending arrest warrant.
No arrest happens, sir. What are you?
But it is
what kind
very
of
much urgent.
arrest happens when you don't pay. What is the law?
Law is that my
What is the law?
law. If we
Arrest happens.
warrant
Huh?
has warrant should be issued against the person.
Distress warrant should be issued.
But urgency is
Not
there.
warrant.
Yes.
My lord,
Well, let the matter.
with your
Let
lordship,
the matter be tomorrow, my lord.
Give it.
my lord,
Lord, I am praying for leave to put the matter in vacation bench, my lord. Vacation bench.
Sorry.
I am praying leave.
What is the urgency, sir?
Urgency is that without following surface proceeding, without the properties, the subject matter of any mortgage, I have
Proceeding, go to the DRT.
my lord, with your lordships,
Go to DRT. Surface proceeding. I'm not touching it.
surface property.
Section 14. Section 14. Not touching it.
my lord, with your lordship,
Yes.
kind leave, my lord, I'm mentioning one matter, appellate side matter, my lord, which your lordships heard on 19th of May, this one.
Yes.
My lord, I'm for the municipality, my lord. I prayed for 8 weeks time for, there was a order of demolition, my lord, under the Kamarate municipality. My lord, yesterday I obtained the order from the server. Now it is 5 weeks from 4 weeks. My lord, the problem is that, my lord, these are, as your lordships observed, that this is a huge building. My lord, the municipality did not.
That's all right. You do partial, you come back, we'll extend it.
My lord,
That Kamarati.
Yes, Kamarate.
Yes, you come back, do something and come back.
my lord, may I be permitted to
Do
mention?
something so that it shows. Seek extension. We'll see that.
Mm.
At least show your bona fide that you're acting, you're doing something. If you intend to do something in 4 weeks also, you can do a lot.
As it
At
is-
least 2 floors down, few more left, another 2 weeks. There's no difficulty.
My lord, may I be permitted?
That, my lord, leave to grant move before the vacation bench, my lord. I have mentioned twice in your court, my lord, but actually the urgency is, it was directed by the Justice Aniruddha Roy that to demolish the illegal structure, and it has been demolished partly, my lord. And the respondent, what he did, he has reconstructed the demolished part and he is inducting the tenant. And by forging my signature, I am the landlord. By forging my signature, he is inducting the
Madam, forgery, go to the,
my lord, but
file your case before the
yes,
police authorities.
been started
As far
with-
as unauthorized construction is concerned, no urgency, it will be demolished in accordance with law. Yes.
My lord,
May I permit to mention a matter of the Honorable Justice Amrita Sinha determination, Your
Yes,
Lordship.
sir.
There's a matter running in the item number 20 in Lordship list. Your Lordship, the urgency involved in the matter, the petitioner's children was stuck in UAE. Their residence visa was expired in March 2025. 59 days extension has been given, Your Lordship, to regularize the same. And petitioner unable to go because when he came to India for some purpose for visit native place for some work. When he about to leave UAE, the petitioner passport was impounded, and thereafter, Lordship, he filed an application phrase for the for issuance phase passport, and the till date passport has been not been issued. 8 May matter was taken up by the Honorable Justice Sinha, passed an order, released the matter on 14th May, and to file a report to Badipur police station. However, due to some
There is
business
no-
of the court, Your Lordship,
There is no
kindly-
urgency.
Your Lordship, I'm
Impounding
mentioning
is a-
upon notice, Your
sir,
Lordship.
Impounding is a procedure which will culminate to its
Your-
logical end.
Your
All
Lordship,
right?
thereafter, for the issuance, I already submitted entire documents.
Very
And
good. Let
Your
them
Lordship,
take a call.
Your
No
Lordship, kindly
urgency.
allow me one more
Yes.
minute, Your Lordship. They raised a dispute of regarding the nationality. For the proving by nationality, after the matter order was passed, Badipur police station called me. I submitted my birth certificate,
Very good.
my land return documents, all of the my children birth certificate, each and have been submitted. But till date, they did not.
When did you submit all
ordered-
this?
Your Lordship,
When did you submit all
on the
this?
last week, Your Lordship, I
Last
have already submitted.
So they take
They
action.
did not
They-
forward the papers, Your
All
Lordship. Kindly take up the matter.
No
Your
urgency,
Lordship,
sir.
The
Sorry,
children
sir.
are minor, they will not deport to India and then sent to illegal immigration camp. Your lordship, kindly.
They will not be sent to illegal immigration camp. Impounding of a passport is a procedure which,
My children passport is valid and they are stuck in UAE.
sir, your children passports are valid, not your passport. There's
My
an
passport is impounded.
That's what I'm saying.
Huh.
The procedure will be followed. All right.
Procedure will be followed. If
You have given the documents, they will decide on it.
I want to expedite the procedure, I'm not overlapping the procedure. Your lordship,
Sir,
children are
You have just given the documents, they will decide it. All right. If they don't decide it this week, you mention in the vacation bench.
Your lordship,
Lord,
kindly see now
Lord,
once
may I be
order,
permitted?
Before the
kindly,
vacation bench.
kindly see once the order, your
Sir,
lordship.
mention before the vacation bench.
My lord,
Yes.
may I be permitted?
Permitted to mention this matter to of urgent determination of Honorable Justice Amrita Sinha's bench. My lord, to move before the vacation bench. My lord, this matter, the passport authority has asked the police officer to file a report of the petitioner so that the passport can be renewed. My lord, he wants to visit USA to meet his daughter. My lord, it's more than 6 months and they are not giving any report. The authority is not submitting any report so that the passport can be renewed.
You filed a renewal of the passport.
Yes, we have filed a renewal application of the passport.
You filed it in Tatkal, you filed it in original, ordinary course.
Order in course. My lord, it's filed in the month of November, December. And yet they have not submitted any report, my lord.
So they'll take action. What is the urgency? Because you want to meet your daughter.
My lord, she is staying in US and she needs my help for
How long she has been staying in USA, madam?
some years, my lord.
So why does she need your help right now? That you can't wait for few more months?
My lord, it's been more than 6 months. My lord, they have not submitted any report. It's
Give it.
My lord,
My lord, with regard to item number 2468 of my lord list, my lord. In this matter, my lord, we are, my lord, the hawkers, my lord, running our business in the new market area. Now, my lord, there is no urgency in this matter till 15th of May. In 15th of May, the member of town vending committee filed a writ petition before your lordship against the Calcutta Municipal Corporation. And, my lord, your lordship please to pass an order directing, my lord, to take steps for those who are illegally running the business in the Chorong area. Now, we are applying before the town vending committee for long years ago. Our application is still kept in abeyance by the town vending committee. On the other hand, they just to evict us, they filed this writ petition and taking the order from your lordship. Now, our predicament is that pursuant to this order, we will be evicted. So, our urgency is that since your lordship directed them to...
This is a decision taken by the town vending committee itself, where you can't sit on the blacktop.
Yes, we are not sitting on the blacktop, but we are...
The blacktop portion and 2/3 of the pavement area. That is what the
pavement area.
Taken. Yes.
We are running business in the pavement area, for pretty long years.
This is 1/3 of the pavement area. You are occupying the entire pavement area.
No, not the occupying. Our application
before the decision of the town vending committee.
Yes,
this court has not passed any order which is in against the town vending committee.
No, not against the town vending committee. What happened, our application is pending before the town vending committee.
So you are aggrieved by this order, you challenge it.
We have filed this writ petition. Now what happened? The member of a town vending committee, they come up before this court against non-implementation of the order of the town vending committee by the KMC.
Right.
Now, the story behind this, they want to evict us, and on our places, they induct their own followers or own persons. We are, the urgency is that your lordship directed them to take steps within 3 weeks.
Yes.
The vacation, within 3 weeks, the vacation is there.
Right.
And matter is appearing in the list. What we are praying, if your lordship kindly take it up this matter at 2 p.m. or tomorrow, as per my lord's convenience. Otherwise, what happens?
Give your mentioning slip, we'll see that.
my lord, may I be permitted
Otherwise, you challenge this order.
We are not a party even.
So what? You are aggrieved by this order.
Yes, that can, but
you can always challenge it.
But our matter is pending for your lordship. That is the reason,
We'll see that, sir.
My lord,
To challenge this order.
my lord, may I?
Kindly hear out our application.
We'll see that. We'll see that.
My lord, may I be permitted to mention?
Challenge this order. That's better.
My lord, may I be permitted?
That'll be much better. That's much better, sir. I'm telling you.
Let us try before your lordship.
My lord, may I be permitted to mention a matter of the original site, lordship? Although I had mentioned it yesterday, my lord, the schools that require urgent repairing, lordship, will kindly once see the pictures, my lord. That is the urgency, lordship.
La Martiniere.
Well, as
Yes.
if your lordships would permit me also, I'm
The roof, lordship, kindly takes a look at the.
well as the matter is
My lord.
absolutely urgent. There was an accident which took place. A portion of the roof collapsed. We have been corresponding with the corporation since February. This is a heritage building, so it requires certain permission for even restoration and repairing work. Well, there's extreme urgency in this matter. This is a very old and a premier school in the city.
Sir, you have your colleague, I think, who's
Mal-
doing a better job.
I'm sorry.
Lordship,
Yes.
any day we have put them to notice, lordship. Any day, lordship, like today, tomorrow, any time, my lord.
Tomorrow.
Tomorrow, I'm deeply obliged, my lord. It's original
Grateful
site.
months.
This is the original side.
Original
So you
site,
serve
my
them,
lord,
we'll have it today.
today.
We'll have it today after I get up from the division bench. Any mentioning, sir?
Since your
You
lordship,
must have given you a slip.
yes, your lordship, I have served the notice to the your lordship other side.
What
The
is it to-
urgency, your lordship, the urgency is that, your lordship, the petitioner, your lordship, divorcing mother. Your lordship, her son, the petitioner, your lordship, intended to, your lordship, the correct the name of the your lordship, her son in date of birth, your lordship, issued by your lordship on municipality. Now, your lordship, she filed an affidavit, your lordship, to the municipality. Despite your lordship service of the affidavit as well, your lordship, representation, the name of the date of name of the your lordship, the child, yet not been your lordship corrected by the municipality, your lordship. Now, your lordship, form has been your lordship released. So, your lordship, the petitioner
Give me
could
a
be
slip, we'll see.
kindly, your lordship.
My lord, subject to the leave of the court, my lord. In fact, in my case, my lord was pleased to entertain my mentioning in the other occasion also.
I would have taken your slip, sir.
At the chance, but the urgency remained as it is. In fact, my life is in danger. In view of the illegal construction carried out by the private respondent in an unholy support by the municipal authority. But in this stage, my lord, if your lordship entertain this matter by today or tomorrow, otherwise, my lord, if your lordship kindly release the matter, I will take chance in the vacation.
Sir, you can always take chance in the vacation bench without my releasing the matter.
My lord,
You don't need release from this court.
no, my lord, matter is running before your lordship.
Yes, still you can mention it, sir.
My lord,
You are a senior lawyer at the bar. I'm sure you know your rights. So you don't need me to release the matter, and I will not release the matter.
in convention, unless one court is releasing
No, sir, you're wrong.
other.
You're wrong.
What
We were
happened-
also on that side.
My past experience is once they release for the vacation bench, if the vacation bench.
You give your
doesn't-
slip, I'll see. You give your slip, we'll see that.
Lordship, may I be, Lordship, may I be present a matter for upgradation? Lordship,
Give
it's
your
a,
slip. Mr. Banerjee.
May I have my lords kindly to mention item 53 and 54 of my lord's list today. This is in connection with the APJ Park School which is running. The corporation has served up an intimation that it will take coercive measures within 7 days without having made any assessment, lord, on the school in accordance with law. They can't go back for 3 years, for more than 3 years behind. They have made a purported assessment, that too without serving a copy of the order on us, from 25 years ago.
Go before the tribunal. get
Here,
it.
my lord, I don't have access to the tribunal because no copy of the order is made available to me, number one. Number two is, it's in the teeth of a division bench judgment of your lordship's court, my lord, which say that this can't be heard.
Justice Mukherjee's judgment.
Justice
of 3
Mukherjee
years.
division bench, my lord.
No,
My lord, we'll,
No. not at all.
then, my lord, there are other points also. The only difficulty is, my lord, once the thing closes, my lord, if they take steps, my lord, the school will be in jeopardy. Kindly, my lord, hear out, my lord, 53 and 54. If your lordship, my lord, some workable arrangement can be made.
Nothing, Mr. Banerjee. It's not that.
Item number, this is, my lord, this is a matter pending before my lord. This is
You
appearing.
know, these corporations do nothing. Relax.
They sent a letter yesterday also saying
Keep
that
sending letters every day.
so they'll come, and if they seal it up, my lord, the
You can
school
do
will be.
nothing. If they seal it up, you come here, we'll de-seal it.
This
Mr. Mukherjee, you know it.
this is appearing in my lord's monthly list, my lord. An order of demolition is under challenge, my lord.
Yes.
This pertains to, my lord, a building, my lord, existing prior to 1970, when even the corporation does not have jurisdiction over that area. My lord, all these documents were submitted at the time of hearing. Nothing was considered. Even the engineer who has passed the order, my lord,
You are
has
challenging the demolition order.
yes, my lord. My lord, I have
Which corporation is
my Howrah Municipal Corporation, my lord. Yesterday, my lord, all on a sudden they have come, my lord. They have, my lord, partly demolished the entire roof. My lord, this building, my lord, is existing prior to 1970s. My lord, all the documents were, my lord, submitted at the time of hearing. Nothing was considered. Even the person who has passed the order of demolition, my lord, has not heard us. The person, my lord, who has heard us was retired. Somebody else came and, my lord, passed an order, my lord, without hearing us. My lord, yesterday, my lord, already, my lord, demolition took place of the entire roof, my lord. I have been told, my lord, today they will also come, my lord, and, my lord, demolish the entire, my lord.
What documents you have to support that's a 1970 construction?
My lord, when it was, my lord, under the Gram Panchayat, not even the corporation, my lord, I have, my lord, the tax bills and other things, my lord, I have submitted to show, my lord, that, and, my lord, the
tax bills regarding the construction. Does your tax
my lord, showing the, my lord, yes.
Show me from the document that there is any sign of construction on the property.
Yes.
Don't show me that you're owner of the property.
Now, these are, my lord, tax bills with regard to that premises of the Gram Panchayat when the corporation does not have the jurisdiction over that area. My lord, later, my lord, after
So
around
don't show me tax bill which establishes your right over the property. You show me assessment where you have paid property tax regarding the entire construction in the year 1970.
Yes, there is a document, my lord. Like it's in.
It's in Bangla?
My lord.
Vernacular?
Yes, my lord. Bengali, my lord.
Read it.
Bengali, my lord. It's in.
Read it.
My lord, it's a document of, my lord, 19 December 1987, my lord. It's, my lord, with.
No, you said 1970.
My lord, it's prior to 1970s, my lord. That was my contention, my lord. And I have annexed these documents, my lord.
Sir, what is the document?
My lord, the document, my lord, is, my lord.
Give your mentioning slip, we'll see that.
My lord, kindly considers, my lord,
Give
that.
your mentioning slip.
Well, yesterday there has been a part demolition, my lord.
Give your mentioning slip. Give your mentioning slip. We'll see.
I will.
May I get your lordship's kind leave to mention one original site matter running in your lordship's list as item number 18.
Yes.
Your lordship, the urgency is your lordship. The building is 4-storied building on the main road of the street, Chitranjan Avenue. Your lordship, the municipality, KMC has also passed an order for demolition.
Very good.
But regarding the occupants, your lordship, there was problem, but we are ready to rehabilitate the occupants as because your lordship, yesterday only, a part of the building fell inside the building. Your lordship, it creates a lots of nuisance. Your lordship, it needs immediate demolition.
Lord, may I have your lordship's
Very-
my lord,
Yes.
my lord, yesterday your lordship was pleased enough to reject one of the writ petitions item now for. Will it be your lordship's pleasure, my lord, if your lordship kindly, my lord, put the order in the server, my lord?
Yes, we'll try to do it today.
Grateful, my lord.
Well, at the cost of being reprimanded, Milord, I am once again renewing my prayer for the matter to be taken up, Milord, from the list of Justice Sinha, Milord. But I assure my lord, I am not an unauthorized illegal occupant. I am under a contract residing, carrying out business at the railway station across the country.
Madam, you give your slip, we'll see.
I'm obliged. I'm obliged.
Call out the list.
Yes, my lord, I am for the petitioner. This is an application for registration.
My lord, I am for the Kolkata Municipal Corporation. The difficulty is that the application has not been served upon us.
It was served. It has been served. Original evidence service is lying with the record. And I am having a copy of the same.
It has not reached us. It has served in the
Somebody called me up from KMC yesterday and asked me about the cases. Anyway, it is merely an application for registration. The thing is this.
Give a copy, sir. Give a copy.
Copy the watch. And I copy them too. It affidavit of service. Now, registration application copy.
Petition guy.
What
is the petition?
I'll serve a copy in course of the day. Actually, the thing is this: inadvertently, I have missed your lordship's list on that day. Acha, I have handed over a copy right now. I have stated in paragraph number 4 of my registration application that simply I have missed the list. Actually, in the previous bench, original said matters used to be taken up for the whole day on Wednesday, but your lordship is taking up these matters on Thursdays. And when I realized that this matter has been listed in the afternoon, in the second half, I rushed before your lordship's courts and I have discovered the matter has been already called on and dismissed for default. On the 3rd of
Petitioner has
April.
filed an application for restoration. Full stop. The present writ petition was dismissed for non-prosecution on 3/4/2025. The present application is allowed for the reasons stated in the said application. Writ petition is restored to its original position.
And lordship, one more issue is this. One more issue is there. I inadvertently I have forgot to annex the last 3 pages of the last annexure. That is in page 71, last annexure
of the main petition.
Last 3 pages. Just check. It is there only up to page 72 probably. Page 71. From 72 to 74, these 3 pages are missing. So may I be permitted to...
Petitioner is granted liberty to... Petitioner states that what is the date of this order?
Which order?
Last page.
Order impugned order,
yes.
It is 21st of July 2023.
Petitioner states that the copy of the impugned order has only 1 page of the impugned order has been annexed with the writ petition. He seeks liberty to file the complete impugned order. Full stop. Liberty is granted. The petitioner shall place on record the complete impugned order.
Here and now I am annexing it. Here and now.
You file it in the registry.
Acha, okay.
I is disposed of.
Lord, let the matter come up for hearing then on which date? Yes. If
matter will be listed for hearing on 26 June.
I'm obliged to lordship.
26 June, lordship. Obliged to lordship.
You supply a copy to them.
Lordship.
After putting the pages, supply a copy to them.
Now, in the copy is otherwise all right. In the copy, all the pages are there. Okay, I will replace the copy. Lordship.
My lord, in this matter, my lord. My lord, on the last occasion, lordship directed us to actually file an APDP to the effect, my lord, the applicants building and regarding the issue.
Yes.
My lord, that report is with me, but my lord, that APDP portion, my lord. If your lordship kindly take it after vacation, I can actually file it.
My lord, on the last...
There is a stay order for actually not to do anything regarding the applicants building.
There's a...
regarding the applicants who moved before your lordship, that is stay order is there. We are not actually touching his building.
Yes.
Though, my lord, in the report, my lord, from the report it can be seen, but as per your lordship's direction, that has not been done. APDP, my lord, that is in the last.
Tenant counsel for the respondent.
My lord,
Calcutta Municipal Corporation.
My lord, another I need to tell you that another on the last occasion, CSC has entered the premises to cut the electricity apparently in accordance to the last order.
Very good.
So they are saying that now they don't have the report. They are not coming clean before you. On the last occasion, you had said that nothing was done in satisfaction of this court.
Today the report 2 weeks, further time of 2 weeks to file his report.
Kindly make this a last chance because the corporation is really dragging his feet. That executive engineer is not coming clean before you. He is deliberately dragging this issue. Since we have pointed out that on the first occasion, the affidavit in the form of report, the premises number, they had said that we don't have sanctions plan. Now they can't prove that since we have showed you in front of your lordship that we have a valid sanction plan issued by them.
Pursuant to your lordship, sir, we are doing nothing. Now, my lord, that is electricity.
Then my lord, then delete our premises from the writ petition. I would pray before your honor, then delete it.
Already filed a report. List after 4 weeks.
My lord, I am appealing for the petitioner in this matter, my lord. GA number 1 of 2025 has not been served upon me, my lord.
Yes, he has new. Because you are not available at the first place.
Copy may be served upon me, my lord.
He has refused on the last occasion.
Maybe.
The advocate on record.
You are not.
My lord, another thing. My lord, kindly hear me out. My lord, kindly hear me out. The petitioner's address, the address is wrong. But we have served the copy on that address also.
Yes.
It is wrong. It is showing wrong.
Give a copy to the petitioner. List after 4 weeks.
আপনার advocate refuse করছে কি বলবো এই যে কি নাম হয়েছে কি বলবো আপনার আপনি you are not the advocate also এই যে এই সুইটি
He is not.
you have not informed me not informed me
Yes.
I am appealing for the Kolkata Municipal Corporation.
Mr. Karjar, yes. Yes, Mr. Manager.
Lordship, I'm led by Mr. Joydeep Kaur.
Do not want to trouble your lordship this side of the vacation, my lord, with a very heavy argument. This requires one. This is in connection with, my lord, challenging the constitutional validity of certain provisions of the KMC Act, my lord.
Pleadings are complete.
Pleadings in connection with the writ are complete.
Filing supplementary affidavit.
No, there's only one. There's only one. I think they are required to file a comprehensive rejoinder.
The last time he filed a supplementary affidavit. Do you have a copy of that? So we need to only deal with that. Rest, all pleadings are complete.
And I have a very humble request since Mr. Kaur is here. The client is not a fly-by-night operator. He's also not someone who's in default of taxes. Whatever taxes he had paid till date, my lord, that has been taken. Now, my lord, with retrospective effect from 22 years behind, purported assessments have been made and he's been made to pay tax. We say that they can't do that under the KMC Act 1980. In any event, they seek shelter under a provision which has been newly introduced, that is 232B. We say that 232B cannot, my lord, really undo the effect of settled judgments which are there. And the legislature has the right to make new law, but can't make it retrospective, open-ended. That has been decided by my lord's court and also, my lord, by the Honorable Apex Court on a number of occasions. I was humbly beseeching this. I have taken out an application where I propose to pay, because I don't want a tax holiday. I propose to pay, my lord, an amount of money which I have calculated at 45 lakhs. They allege that the total dues along with interest and penalty are to the tune of, according to them, 13 crores.
16 crores.
It was 13 last time. In about a week and a half's time, it has become 16. I can understand that the rates of interest would be a Dalal Street shareholding dealer's delight. I mean, 13 crores in the beginning of May, 16 crores somewhere in the middle of May. But I'm not. But I'm not. No, it says.
They want my management to be corrected.
Fair enough. No, 13 crores was what Ms. Sengupta had said. Mr. Kaur need not. I today.
This is their annex to their application.
Today, my lord, I am not taking your lordship into that. Only one thing, my lord. I have told the client that 44 lakhs looks to be a very bad figure when pitched with the last 3 years of principal amount or what they have charged. Because according to us, our sheet anchor is that you cannot take taxes beyond 3 years from that particular date. There's a statutory provision. Justice Mukherjee's judgment comes much later. Please, my lord, have us look at the statutory provision only. Please, 573, my lord. Sahujain, wait karo. Wait karo. Recovery of certain dues of corporation. This is in connection with recovery. This has now been made applicable in connection with collection as well, with assessment as well. Save as otherwise provided in this act or the rules or the regulations made thereunder, any sum due to the corporation on account of any charge, cost, expense, fee, rate, or rent, or on any other account under this act or the rules or the regulations made thereunder, shall be recoverable from the person from whom such sum is due as if it were a consolidated rate, provided that no proceedings for the recovery of any such sum under this section shall be commenced after the lapse of 3 years from the date on which such sum becomes due. So there's a statutory moratorium of 3 years, beyond which you can't raise a demand in collection. Now, this fiction.
The order which I have passed, we go beyond 3 years.
My lords?
In your case only, I have passed an order.
No, Wow Momo case, my lord. My lord has gone into the merits of the order. But my lord has given me. We say it's a. Permit me to use the expression on a lighter note. Nehle pe dehla. I was saying that there's no statutory alternative remedy because it can't stand in my way. I showed Whirlpool and the like. My lord was impressed. My lord said very well, there's no statutory alternative remedy. I will examine it. Then my lord went into the order of the hearing officer and he said that whatever he's come to a finding on judicial review, I find no error or infirmity, and therefore my lord, it is dismissed. So that's a classic. Once again, permit me to use the expression nehle pe dehla. आप अगर alternative remedy लेके बहुत ज़्यादा मुझे flexible करेंगे तो merit में जाके आपके against on a completely lighter note, my lord, completely lighter note. But this one, this 573, which is the outer limit for recovery of taxes, recovery, not assessment. This has now been read into assessment as well. Hence, Justice Mukherjee's judgment. I just hope,
But
Lord.
what about 182, 184?
Yes, I'll tell you, Lordship, what. 182 says that there is a provision for self-assessment. Corporation's consistent rebuttal to this is, if there were any taxable events at X point of time, you ought to have provided a self-assessment under 182, you as the assessee. If you've not done that, and we come to know that even 50 years down the line, we have the right to stretch back to that 50 years and reopen that assessment. To that, my lord, there are three-pronged answers. One is, this bar of limitation which is introduced is a bar in rem. This accounts for all and every incident and still says that you can't go beyond 3 years. That's the law. Corporation challenged it in an SLP. I brought that order also. The SLP has been dismissed. There's no merger, but my lord, so Sahu Jain today is the law which governs West Bengal. Please see, my lord, this is Sahu Jain in SLP. Specially petition is dismissed. So what's the effect of Sahu Jain, my lord? Effect of Sahu Jain is, if you make a retrospective assessment today, please do not make it for a period for more than 3 years back, because otherwise the assessee will be at 6s and 7s. Answer to 182 is this. If your lordship looks at 182, it's not a mandatory provision. I'll tell you, lordship, why it's not a mandatory provision of filing returns. Please come, my lord, to the offences and penalties section, my lord, of the Act. There's an offences and penalties section which makes certain omissions under the Act penal. Please come to Schedule 6 of the Act. The Act itself contains a Schedule 6. No. Now, my lord, there are certain offences that are given. Now, this is also in connection with statutory provision 610. Please have a look at 610 of the Act, please. Offences and penalties. Punishment for certain offences. Whoever contravenes any provision of any of the sections, subsections, clauses or provisos, or any other provision of this Act mentioned in column 1 of Schedule 6, or fails to comply with any order or direction lawfully extended, shall be punishable with fine and additional fine. So these are offences and penalties. Now, if your lordship looks at the table that is relatable, that's Schedule 6.
Yes.
Please see Schedule 6 penalties, 610.
Yes.
Please see, my lord, what are the alleged shortcomings which are not penal and which are the ones that are penal. Please see the column to the extreme left. 101, 160, 181. 181 means requisition for return for purposes of assessment of annual valuation. If the corporation asks of me any information under 181 which I don't give, then that's a violation. That's for that a penalty is given, 300 rupees, fine or imprisonment, whichever may be imposed. But for 182 or 182A, there is no such offense prescribed, which means one of the manners in which you can understand whether a statutory provision is mandatory or directory is to see whether for its breach, any offense or penalty is prescribed under the Act. So 182, my lord, is an enabling provision. It does not stare either way. My non-furnishing of 182 does not prevent corporation from assessing. Similarly, my non-furnishing of 182 does not prevent me from taking appropriate grounds to challenge the purported assessments. Today, my lord, Justice Mukherjee's judgment, my lord, I was fortunate enough, my lord, to be assisting, my lord, a very heavy argument, my lord, on constitutional law. The judgment has been somehow precise, but in its precision, it may have lost a bit of its force. Now, my lord, the precision on which I am, my lord, trying to draw your lordship's attention, which the Supreme Court also found no reason to interfere with, is this. Please come to paragraph 25. They were considering whether corporation can go back to an unlimited period of time when it sees that an assessment is required to be made. Now, look, paragraph 25, it was discussing the power under the second proviso, which gave the corporation the power to go back at any time. Para 25, the power conferred on the municipal commissioner to revise the annual valuation of land or building under section 179(2) second proviso was indeed unlimited in point of time and very wide in its amplitude. Any piece of legislation, it will be, where unguided or uncanalized power is given to an authority to that extent invalid. Therefore, the power conferred on the commissioner, in my opinion, is indeed so unlimited that it falls foul of Article 14 of the Constitution of India. So the High Court found, my lord, that that power was uncanalized in terms of proximity or antiquity, and therefore the High Court said it falls foul of 14 and is void. But the High Court then read it down, saying, Lord, kindly see paragraph 26. However, in the Supreme Court cases discussed by me above, similar powers were conferred on the authority. In the case of New Delhi Municipal Committee, the Life Insurance Corporation of India reported in AIR 1977, Supreme Court 2134. Similar power was conferred on the Municipal Committee under the Punjab Municipal Act to amend the assessment lists. In all these matters, including the municipal matter, the Supreme Court did not declare the provisions as ultra vires, but tried to read down the rigors of the provision by implying words into the offending provision so as to make a provision reasonable. It implied the words within the reasonable time after the phrase at any time to make the section workable. Same thing is done in our case. Now, kindly see 27. We adopt the same procedure. So the court is not striking down the provision, it is reading it down. The commissioner can only have the power to revise a valuation within a reasonable period of time. Now, what is the reasonable period? This also court says. In the case of Santosh Kumar Shivgonda Patil versus Bala Saheb Tukaram Chevrolet, reported in such and such, the Supreme Court computed reasonable time in the subject act to be 3 years. Now, my lord, kindly see section 573, the section I showed you, lordship. In section 573 of the Kolkata Municipal Corporation Act 1980, the corporation has the power to recover any sum by initiating a proceeding within 3 years from the date such sum became due and payable. Therefore, on a proper interpretation of the proviso and upon reading it down to save it from unconstitutionality, the period for which valuation of the property can be raised must not be more than 3 years before the date of the revising order. Today, my lord, the revising order of the corporation in my case has been in the year 2024, and it has sought to reopen from 2005-06, 10 or 11 assessments back to back. This is forbidden by the law, my lord, that stands. There's only one escape route for the corporation which the corporation can take. My lord, during this, the provisions of section 232B were not in force. Now, my lord, kindly see just 232B. I can deal with it in a second. And I'm saying this because of interim relief, otherwise I'll be undone. If they steamroll me with a 12 crore demand,
we will hear the matter.
Yes, my lord kindly does that. In the meantime, lord, I'm putting in a crore of rupees. Please, my lord, let them not take any coercive step till your lordship hears.
We don't depend on charities. Lord, your lordships may kindly, Lord, have a look at his current, Lord, tax, which is due. In 1 year, he has to pay 2 crore 15,57,250. This is in 1 year. This is his tax that he has to pay. In the first, your lordships will find these are, Lord, first quarter to fourth quarter, 25-26. In 1 year, this is, Lord, the tax which is falling due. And Lord, this is happening year after year. What happened is, Lord, they did not disclose that they had multiple tenants in the property, inducted multiple tenants. When, Lord, letters were sent regularly, nothing happened.
No, we responded to the letters.
I'm not going to take your lordship through the brief. I'll just, Lord, mention the bare facts. And therefore, Lord, an inspection was caused and it transpired because, Lord, various tenants, they were written.
If you come to a understanding, then otherwise I have to hear the petition and decide it, because I'm not.
No, it's difficult to hear the petition decide. I will also not be pressing, my lord, for the petition to be heard out this side of the vacation. Vacation knocking the door. I am only saying this much. I am only saying this much to Mr. Card. He's appearing there. I couldn't have said that to Mr. Cars Jr. I can say it to him. We are addressing the court on a point of law. The regular session of court ceases from tomorrow. We come back on the 9th. If this is the first matter on the 9th, I cannot stand in the way, subject to business of the court. In the meantime, to show our bona fides, we are putting in some amount. Let them not.
43 lakhs.
What happens is,
40 lakhs, I will. No, if the writ doesn't succeed, I get saddled with interest and penalty. I am saying, my lord, I am paying up to date. No, I am paying up to date tax. I'm sorry, Mr. Cord will kindly take instruction. I am paying up to date tax till date on the valuation on which I am paying. Today, my lord, in 2024, kindly see the iniquity of it. The hearing officer sits and by one stroke of pen makes me liable to make differential payments from 2005. My lord, I am undone. And it's in the teeth of Justice Mukherjee's division bench order, which the Supreme Court did not interfere with. So today, my lord, I'll be undone if they use their executive force to crush me in the meantime during the vacations. My lord, that section incorporated does not help you. If that section revives section 179 proviso, then Sahu Jain also revives. Sahu Jain's bar also revives. You can't have revival of a statutory provision minus the High Court's direction. We'll argue it. In the meantime, Lord, let them not do anything adverse to us.
Not in the meantime, I'm not passing any interim. No interim order.
Lord, some protection.
I'm ready to hear the petition completely, even today also.
Lord, today I'll not trouble your lordship, Lord. Why would I trouble your lordship?
I'm ready to be troubled. I'll sit till 6 o'clock. I'll hear the petition. I'll decide. By interim order, I am not. I have seen it.
Lord, then, Lord, if some amount we can secure, if some amount we can put
that
in.
could have been.
Mr.
Carr would be gracious enough to do that.
No, but Mr. Carr has been instructed not to be gracious enough. Personally speaking, he's the most gracious. Personally speaking, he's the most gracious person on earth. We have all benefited from Lord his magnanimity in and out of court. It's not helping me now. I can understand it's not helping me.
Lord,
all the smiles are directed only to court and not towards me. I can understand.
I can only say this, that going by his own logic, 2 crore and odd is per year, 3 years. So let him deposit 7 crores for the time being, and then we come back and get the matter heard.
7 crores, at the old rate of 3 years, it comes to 44 lakhs. Now it is compounding with interest and penalty. It's coming to 16 crores, my lord.
Deposit 50% of that.
50% of the principal. What's the principal amount?
13 crores and odd. 13 crores and odd.
Yeah, correct. Okay. My lord, could it be 25% just for survival's sake? My lord, we need to survive to fight this litigation. I assure your lordships, these are not fly-by-night operators who are going to keep the thing outstanding.
I'm not saying that. And they will recover it.
Then Lord, after your lordship hears it, my lord, after your lordship hears it.
It's a commercial building.
Yes. There's absolutely no one is, my lord, here, my lord, I am also receiving rents from what I am getting.
So pay 50%. I'll grant you stay. We'll hear it.
Could we do this, my lord? Could we secure, pay 25% and secure 25%? Please, my lord, kindly substitute the securities. Kindly substitute it.
Mr. Carr,
Lord, this 50%, let it be paid. Lord, we'll keep it in a separate account. And Lord, your lordship can hear out the matter.
Suspense Raghbor. My lord, I had only one prayer. The amount that we'll pay, if your lordship is so pleased not to permit us, let that be kept aside.
that's what he said.
Adjusted off, because if they keep it in the suspense account, they will adjust it against interest and penalty, and I'll be undone. My principal demand will stare at me. Let them keep it separately, adjust it in terms of orders made by honorable court.
There is a separate account maintained by the municipality, which is called the suspense account. I'll keep it there.
The suspense account is not free of suspense. What they do is they put it in that suspense account. Some morning you will find it has been adjusted against interest and penalty, and no one, even with the court's brilliance, will be able to decode how they've adjusted.
Interest and penalty will be subject to the decision
therefore,
of your
let, yes, therefore let this money be held.
Yes.
I have an instruction to argue the matter today. No, sir, my wife. Why would I? Why would I?
No, I'm ready to hear. I'm sitting here to. I'll have some work in the vacation.
Correct. Then may I argue it? I mean, no, why? I've never done such a thing. Why? Vacations ek din pehle. But we'll put in 25, we'll put in some more. No, they're not putting it in. Instructions to argue. My instructions are to argue. They were very cruel instructions. Can we come? It'll be, but practically, my lord, vacations are knocking on the door, my lord. As far as I am concerned, my mind is somewhere on the beaches. I mean, it's very difficult to bring it back. Very difficult to bring it back.
I'm not traveling, Mr. Banerjee. So my mind is absolutely here.
Here?
I'll have some work to do in vacation. I'll finish it off in vacation.
Then, Lord, I'll bring it back from the beach, Lord. Then I can start, Lord, if your lordship permits. Do I do it now? Do I do it at a time when your lordship comes back after the vacation, after division bench?
Division bench is 2 o'clock.
2 o'clock. So 2:45, my lord is free.
No, I have kept some matters. You do it now.
Eh?
I would request Mr. Banerjee.
Kiki.
Sahu Jain matter is item 5.
Oh, there's another Sahu Jain who wants to. Huh.
Item 5.
Same South.
Same South.
My matter. The part is judgment we are talking about.
So then we'll have both of them after vacation.
दोनों को एक साथ रख के after vacation में.
Matter, I think Mr. Banerjee.
No, whatever, Lord, whoever leads, my lord, my learned senior friend is more competent than five me put together, my lord. So there's no difficulty, my lord. If he leads me, I have no difficulty. If your lordship then clubs up both these matters and keeps it, and then I will have to leave it on the good offices of Mr. Cart to see that he doesn't steamroll me in the meantime. If he does it, my lord, then I'm out of court. What can we do?
Yeah.
So some kind of the final document that we give to demonstrate that it happened. And if the supplementary evidence cannot record, I will be the copy court.
Permit us to file an exception.
Exception to the supplement.
আমরা কি argue করবো? জিজ্ঞেস করা।
And also, Lord, an exception to the supplement.
My instruction for my instruction.
There, humble prayer to the lordship. 9th item 1. Year 1 will come back to your lordship because
my instructions, my cruel instructions
Let
are
me be
still not
very,
to argue.
very honest and candid. So now I will not take your instruction. Now I will.
No. I mean, I'm just thinking, how can I ever even?
Now I'm on the beach.
No, definitely. This was a good one. My lord has these one-liners coming up from time to time. I could see your lordship go to the beach. Lordship, for a brief while, lordship just blanked out. I could see your lordship traveling that.
So let us have this on 24th of June. I'll say why, because I'm not here. If you want, I can put it on 9th of June.
the lordship is not here.
So I'm in the circuit bench.
The lordship is will come back to your lordship. Come back.
So if you want, I can keep it on 9th.
No, আমার
It won't be the regular.
তাহলে একটু বলো না।
24th week.
24th we can
Yeah.
keep it.
24th, my lord, we come back.
All right.
Lordship.
Nothing is going to happen. Tell your clients not to. Nothing is going to happen.
So Lord, at least, Lord, I'm Mr. Cord is here. I can make this request, wish, prayer. We are challenging a provision of a statute,
Yes.
knowing full well that if we fail, we will have a big demand of interest, penalty, and principal staring at us.
Yes.
We are making payment of up-to-date taxes in terms of the old valuation. That is not under dispute.
Right.
Today, my lord, if we are crushed in the meantime by the corporation, then we are undone. Mr. Cord is here. Mr. Cord will assist your lordship with appropriate answers to the questions which we humbly put forward. In the meantime, my lord, till the matter is taken up next, if we are crushed, then my lord, there is no tomorrow.
Full valuation
continue.
My lord, what I understand, my lord, subject to lordship's kind consideration, I believe KMC will exercise its due diligence, whatever they want to exercise, but KMC will be wise enough not to steamroll us when the matter is pending before your lordship.
I don't think so. They'll do it.
I will leave it at that.
Well, I understand, my lord, what is the effect of pendency before your lordship. My lord, only one thing, my lord, we are filing an affidavit, but it is in the legal format because the affidavit has been affirmed in Delhi High Court, the oath commissioner. So, my lord, your lordship will permit us, my lord, so that we can file this before the oath commissioner, Delhi High Court.
The problem
Right,
is then the rules, your own rules trouble us.
My lord,
Your rules trouble us.
client is based in Delhi, my lord, but it is before the oath commission, not a notarized one, my lord.
But client can be based in Delhi, but you know.
I know.
I don't need to tell you.
Client. Then what we can do, my lord,
Yes.
we will get another one.
Get another.
We will get another one, and your lordship will permit us to serve a copy upon Mr. Kaur's client during vacations, so that, my lord, these formalities can be taken care of.
All.
Lord, kindly make it clear that your lordship is not entertaining a prayer for interim order.
No, no, I'm not.
But your lordship will, my lord, will not kindly make any observation to that.
I'm not
Yes.
making, Mr. Carr, I will not make any observation.
Yes.
Then you will start acting.
Yes, then they will start
If
acting.
this court is in session of this matter, then it is expected
Yes, my lord.
that you are not doing it.
Yes, yes, grateful.
That's not how long.
Mr. Carr, nothing is going to happen in 1 month's time.
Yes.
It's not a question of 1 month. The problem
We
is,
will
Lord,
decide this
the
issue.
current dues are falling due.
No, we are paying our current dues. We are paying our current dues. No, we are paying our current. My lord, where is the demand?
Mr. Carr, we will decide this issue. We are not going to.
They are paying, so far as they are concerned, they are paying at the old rate.
We will.
No, that's not the case. That's not the case. That's not the case made out by the KMC. So far as I am concerned.
Yes,
As I am concerned, also, Lord,
That is not there. That is not
a very
there.
long date.
Kindly do not, Lord, restrain our hand.
I am not.
No. There is.
I'm not saying anything, but it is expected of you.
It is
since you are
expected.
here.
Lord, that expectation itself is a restraint.
So I'm going to I'm going to burden your shoulders.
Kindly do not. Kindly, Lord, do
I'm not saying
This-
anything.
This corporation will go dry. Lord,
I-
we
No,
can't, Lord,
I am not saying anything.
But
I am
corporation will
I'm
not go
saying-
dry. There
There
are
are
enough
no
corporations
observations
that
from
go-
this court, but
What
it
is
is
the
expected that if the matter is pending.
Lord, I'll just indicate, Lord, what is the mode of recovery. We can, Lord, attach the rent.
No.
Tenant. We
No.
can
I know.
recover.
No.
I know.
That by that mode, in 1 month, we can't
Hamare
recover
to
the
tenant
entire money.
We don't have any tenants.
Nobody does.
Yes. I have nothing to worry. I have nothing to worry because the matter is pending before your lordship.
We will.
Lord, we are taking the movables. At the highest, we will attach the rent of the
The
and Lord, realize some money from the tenant.
No,
But
my lord. Kindly do not, my lord.
that rent will be a minuscule amount,
After a month,
which is
after the court has had occasion to go into it.
Well, we don't have any
Offer
tenants
of
so far as we are
payment.
concerned.
What are your rents? Your rents are not even, if you're paying 25% also, that would come to more than the rent they are receiving.
But so far as we are concerned, we don't have any tenants.
Good. So we'll have it or. So just learned counsel for this. In this matter, you have filed a supplementary affidavit.
Yes, that has already been taken on record by
Yes.
by Lordship.
Learned counsel for the
Leave to be
respondent.
granted to us to file supplementary affidavit.
I will. I'll just a minute. Item which is item 3.
Yes.
Learned counsel for the respondent, Calcutta Municipal Corporation, senior advocate Mr. Carr, seeks and is granted
My lord, we are
liberty
item
to-
5, my lord.
wait a minute.
I'm sorry.
Liberty to file his exception to the additional supplementary affidavit filed by the petitioner within a period of
Lord, within a week after reopening? Within a week after reopening?
within a period of 3 weeks with advance copy to the petitioner. All right. In item 5, learned counsel for the petitioner seeks and is granted liberty to file additional supplementary affidavit. A copy of the same shall be supplied to the respondent, Calcutta Municipal Corporation. Full stop. Reply, if any, to the same within 2 weeks thereafter. List both these matters for argument on 24th of June.
Grateful.
Oh, actually, it's the original side. We'll have it on Thursday. Sorry, 26th of June.
26th of June. Grateful. So grateful.
You keep it not special, not specially fixed, but we'll keep it up in the list so that we can.
Up in the list, my lord.
Kindly take it up at 2 o'clock. Lord, if
2
it is
o'clock.
not inconvenient.
All right, you keep it at fixed at 2 o'clock.
Grateful. So grateful.
Because this will take some time.
Yes.
It's not going to happen in a day's time. You will come up with all your interesting arguments also.
Yes.
For your lordships to reject. But it's a pleasure arguing with your lordship.
Grateful, my lord. Grateful.
Thank you.
Thank you.
No matter.
3 and 5. That's good.
My lord, in this matter, I am appointed to the Kolkata Municipal Corporation.
Yes.
So far, my lord's order, they are trying to comply with. And in the meantime, they have obtained stay from the building tribunal. This is the order, my lord. As a result.
That's why they're not here.
Yes, that's right.
That's why they're not here.
I know it. My lord, this is the question.
None for the petitioner, dismiss in default.
For the petitioner lordship in this matter, lordship, on the last occasion, lordship has been pleased to direct KMC to file the opposition, lordship. Lordship, then
Respondent seeks and is granted further time of 2 weeks to file his affidavit in opposition. Reply to the same, if any, within 2 weeks thereafter, list after 4 weeks.
Your Lordship, Mr. Arjun Sharma.
Seeks further time of 2 weeks to file her affidavit in opposition, a reply to the same within 2 weeks thereafter.
Your Lordship, Mr. Arjun Shamanto is appearing for the petitioner, Your Lordship. I'm praying for not today, Your Lordship. He's due to some personal difficulty. He's not here.
Who appears?
On last occasion, my lord was directed to serve a copy. No copy has been yet. I have
Give a
received.
copy.
Your Lordship, I will serve it, Your Lordship.
Give it today.
Your Lordship.
Proxy counsel so and so appears and states that the main arguing counsel is indisposed. She prays for a short adjournment. Let this matter be listed on 26th June.
Grateful, Your Lordship.
Eight, before my learned friend starts, Lord. In 8, Lord, respondent number 5 died in 2005. Lord, without adding his heirs as parties to the writ petition, they have filed the writ petition against the dead person. Lord, I pointed out, Lord, as a copy was sent to the address of the dead person, Lord, I pointed out it before the coordinate bench. I directed it to take steps. But instead of adding them parties, he made an application for substitution. Substitution, my lord knows, is made when the person dies during pendency of the case. But the other heirs have none of the heirs have been served. Your lordship kindly direct them to add the parties first.
Who are them?
No, respondent.
Your private respondent.
Not on behalf of the private respondent, there are so many heirs. But a copy was left in the deceased person's residence. That's why I was instructed to point out that this should be added as party, otherwise, and this should be served. Otherwise, it cannot be
we have derived our knowledge because the contempt application was going on in another court, and we were not a party in that contempt application. Therefore, we had no knowledge that the respondent number 5 had passed away. This was pointed out by my learned senior friend. Thereafter, I have taken out the application.
Application for substitution?
Yes, my lord. Because
in 2005 died. Lord, they had knowledge. They were added as party in the contempt application, and Lord, they appeared there, filed application that has been rejected.
The contempt application, as on
against the contempt application, they preferred an appeal. Division bench also dismissed that.
But Lord, it was, I submit before your lordship, even today this contempt application was appearing, and it is appearing in the name of the dead person. It is before courtroom number 30, and the cost list says that yes,
substitution has been made there.
Maybe, but we were not privy to it.
It has been corrected in the record of right.
But it is wrongly appearing in the list. Therefore, my lord, we don't even today. My lord,
what do you want? He wants to substitute respondent number 5.
Yes, Lord.
By his legal heir.
The heirs should be served. Otherwise, Lord, this matter cannot be moved.
Yes, obviously they have to be served.
Yes.
But I'll serve all. I will serve everybody.
Go serve everybody.
Yes, yes.
Learned counsel for the petitioner seeks and is granted. And then I'll make it not today. You serve upon them, you come back.
Great. Great. Great.
Not today.
Item number 9, I am appearing on behalf of the petitioner. My lord, kindly appreciates this is the matter wherein
private respondent, my lord. An appellate said deed petition has been filed by me as well, which has been checked, my lord.
My lord, my case is this petitioner number 1 is a restaurant, authentic Bengali cuisine, and represented by petitioner number 2. And petitioner number 2 is one of the 3 partners of petitioner number 1. My lord.
Mr. Chatterjee, what are you challenging? First, give me the background.
My lord, I have a lease agreement with the landowner. I run a business center. Well, suddenly, and I have the agreement for 60 months.
Yes.
3 months expired. Suddenly, a notice has been given from the assessor collector, respondent number 4, directing to pay rupees 1,25,000 the entire rent, as corporation attached the entire rent, page 88. Page 88, 89. First is 89. No period was disclosed for how many months or how many years I have to pay. But my lord,
Corporation had attached the rent, right?
yes, I have not got any opportunity of hearing. Suddenly they said I have to pay the amount. My lord, kindly comes to page 89 first. This is the notice. Period of assessment not stated. Here they are saying the due amount is 27,37,309. Subsequently, it reached up to 30 lakhs. And thereafter, the second reminder notice is in page 88.
Yes.
Now, my lord, I do not have any objection. I can pay. But the fact is, but I have not received any opportunity of hearing. Number one, no period of assessment has been disclosed. I am there for 60 months only since 1st December 2021. This is middle of 25. Then question arises, for how many months or which is the duration for which I have to pay rupees 30 lakhs?
Yes.
This has to be disclosed in page 89, the notice, which has been pasted on my wall. Now, my lord, landlord, my learned brother, who is appearing on behalf of the petitioner in the appellate side matter, he is saying, no, you do not pay. Now, question arises, if I do not pay, corporation officers will come and close my business. I am ready to pay, but at the same time, whether that will be adjusted with the rent, with the landowner. Landowner is saying, no, it will not be adjusted because there is no such clause in the lease deed.
So that is a dispute between you and the
Absolutely, my lord. But my lord, corporation officers, they have come to close my office, to close my business center. They have attached the rent. My lord, my humble prayer will be the notice which I have been annexed in page 89, that is prima facie illegal because duration has not been stated for which period they have assessed this amount. I was there since 1st December 21. This has to be stated. I am not here before, I was not here before 1st December 2021. The period has to be disclosed. How they have assessed. This is reassessment. I did not get any opportunity of attend the hearing in reassessment. I gathered that initially a hearing date was given on 3rd of January. Subsequently, no hearing was taken place. I did not know whether any date of further hearing will be given or not. Several notices I have given to the landowner to sort out the problem, whether I shall pay the rent directly to the corporation or not.
No, the letter itself, the notice says that you are, read the notice.
My lord.
Read the notice on page 88.
Page 88. Page 88, the second reminder notice.
Yes.
The municipal commissioner was pleased to attach the entire rent of premises number so and so and SSC number so and so in terms of section 195. Accordingly, were directed to remit the entire rent to the tune of rupees 1,25,000. This is per month. But they demanded rupees 30 lakhs. Along with all other charges payable to you, to your landlord, directly to the Kolkata Municipal Corporation, Office of the Assessor Collector, with effect from 1/1/25 until the necessary recovery of the outstanding property tax was completed. I gave notices to the landowner. What should I do? Shall I pay directly to the corporation, or it will be adjusted with the rent as it has been stated? Sorry, there is no particular clause in rent, but in the agreement. But the fact is, shall it be adjusted or not? Landowner is saying no. You should not pay to the corporation directly. Pay to me. If I pay to landowner, Then corporation persons are coming and they are saying, I shall close your business.
Absolutely. So what should the corporation do?
My lord, I need a proper hearing with corporation officers and the landowner.
You're not the assessee.
My lord,
You're not the assessee.
I'm the occupier, my lord.
You're
I'm the
just-
occupier.
You're the occupier. The assessee is there, which is the landlord.
Then my lord,
You have a lease agreement subsisting with your landlord.
Yes, my lord.
There's an arbitration clause in the lease agreement.
Then my lord,
You invoke that, get your money or get your issues decided there. But as far as the corporation is concerned, what is the illegality which they have done?
my lord, corporation should have called the landowner. This is my humble prayer before your lordship, and this should be sorted out with the landowner. Yes, I am the occupier, but my lord, fact is, landowner is not sitting with the corporation. And for that reason, I am suffering.
I don't buy that. Yes, Mr. Mukherjee.
My lord, 3rd January, the date was given, they did not appear. What means, my lord, the landowner did not appear.
Yes, Mr. Mukherjee.
This relates to an assessment under the new regime, that is UAA.
Unit area
Wherein,
Unit area method.
Yes. Now, in that unit area method, your lordship is well aware now by this time that the owner of the property has to file a return in terms of section 182A. And if it is not filed in time, under section 185, I can proceed for suo assessment. So no dispute about it. No return was filed. So corporation proceeded with the suo motu assessment. Now the base, we have taken the variable factorials, including that the entire building is put to commercial use. Now a valuation was arrived at. Now the demand notice was given. Periodic demands were given to the owner of the property, who did not oblige by making payment against those bills. Now we have no other way than to take steps under section 195 read with 225 of the Corporation Act for attachment of the rent. We proceed for the attachment of the rent by that notice what my learned friend is showing at page 89.
Yes.
Now as a tenant, he has the questions what he is raising, that I have no hearing, I have no knowledge, he should not have. The law does not permit so. Law only permits that I will give a notice to the owner of the property. If he fails, then I will proceed. That's a statutory power given to me. Now, whether it would be adjusted. He has got a lease for 5 years. He has said 5 years. 60 months means 5 years. 21 it started. So the unexpired portion of the lease, he will pay. Because I cannot saddle him for the period which I could not take. So whatever is the unexpired portion of the lease, he will go on paying. That would, to that extent, it would be adjusted against the demand. And if anything is left, then we will proceed against the landlord. There are other modes prescribed under the law. I can go for even auction sale of the property, if ultimately it is not paid. So far as to the answer that how it is to be adjusted, section 230 makes it very clear.
Apportionment of person primary.
Well, I am placing 230. Apportionment of property tax by the person primarily liable to pay, save as otherwise provided in this act. The person primarily liable to pay the property tax in respect of any land or building may recover if there be but one occupier of the land or building, from such occupier half of the rate so paid, and may, if there be more than one occupier, recover from each occupier half of such amount as bears to the entire amount of rate so paid by the owner, the same proportion as the value or the portion of the land and building in occupation of such occupier bears to the entire value of such land or building, provided that if there be more than one occupier, such half of the amount may be apportioned and recovered from each occupier
in such proportion as the annual value of the portion occupied by him bears to the total annual value of such land or building. The entire amount of surcharge of any land or building from the occupier of such land or building who uses it for commercial or non-residential purpose, provided that if there is more than one such occupier, the amount of such surcharge may be apportioned and recovered from each such occupier. There is only one occupier over here. In such proportion as the annual value of the portion occupied by him bears to the total annual value of such land and building. With that, your lordship takes 195 and 225. 195 talks about recovery of property tax. On the failure to recover any sum on account of property tax on any land or building from the person primarily liable, therefore, under section 193, the municipal commissioners shall, notwithstanding anything contained in West Bengal Premises Tenancy Act or any other law for the timing in force, recover from every occupier of such land or building by attachment of the rent payable by such occupier a portion of total sum due, which bears as nearly as may be the same proportion to the sum as the rent annually payable by such occupier bears to the total amount of rent annually payable in respect of the whole of such land or building. An occupier from whom any sum is recovered under subsection 1 shall be entitled to be reimbursed by the person primarily liable. The query raised by my learned friend for the payment of such sum, and may in addition to have recourse to other remedies that may be open to him, deduct the amount so recovered from the amount of any rent becoming due from time to time from him to such person. So, my lord, his query stands answered by section 195.
Yes.
So he cannot raise any issue. How long I will pay, whether if there is an hearing. He pays 1,25,000 rupees every month to the landlord. That is not in dispute.
Yes.
And we have got dues from the landlord. So till the unexpired portion of the lease, he will go on paying 1,25,000 every month. And that would be adjusted against the rent because it's a statute says so. It's not that I have to say. The statute says so.
Yes.
My lord, page 88 says that however no payment has been received from your end to date, resulting in outstanding dues amounting to rupees 30,61,000 as on date. Page 88.
That's right. So if there is any, you feel that a higher amount has been deducted, you can always recover it from the landlord in
My
terms
lord,
of your lease.
that liberty is to be given, my lord. Landlord is saying neither you can pay nor he will attend the hearing with corporation. If
That
anyone is
liberty
answerable is
that
landlord.
liberty is already available to you, Mr. Chatterjee, in terms of your lease agreement.
My lord, my case is if anyone is answerable, then answerable is landlord. But he is not sorting out the problem with corporation. If your lordship direct us to pay the amount, we shall pay. But my lord, fact is we shall pray a liberty that it will be adjusted, my lord, with the agreement with landlord.
Right, so.
Or my lord, if I can raise these points before the proper forum.
Yes.
That will also do, my lord. That will also serve our purpose. Otherwise, if I do not pay him, he will give eviction notice to us. But my lord, if your lordship sees his prayer, he has preferred the writ petition assailing the assessment process.
That he should go before the municipal tribunal.
But there is a violation of natural justice. Why am I saying so?
What
Because
violation
there
of
was no prior notice issued to me. An assessment has been made, a bill has been raised that has to be send it to me, but they haven't sent, my lord. Even this notice which my learned senior friend is, my lord, showing to your lordship page 89, my lord, that has been attached, affixed in the said premises. However, in the municipal record itself, my mailing address is somewhere, my lord, else. That has been also addressed in this, my lord, notice as well. But
You are well aware, sir. Don't make all these excuses over here.
no bill I have ever received, my lord. Your lordship will kindly see. And my lord, there is an exaggeration of this amount, my lord. Prior to
So go before the
2020
tribunal.
I have come here for this reason, my lord.
That tribunal is the right forum to decide your case.
Yes, my lord, that order has never been served upon me. That order I have never received. I only came to know about this
Very good. You challenge this only. You are at liberty to challenge it.
My lord, that order may be served upon me. That order has never been served upon me. I only came to know from my learned senior friend's client.
Mr.
who are
Mukherjee,
notice
the
issued by them.
assessment, he has participated in the assessment proceedings?
No.
My lord, here the system is different. Here he has to file a return under
182.
if your lordship sees.
Yes, yes, 182.
And if it is not done, your lordship kindly takes 185. 182A, the return has to come, and 185, the municipal commissioner may at any time make suo motu assessment in any case where a return on the basis of the self-assessment has not been filed. He cannot pray or pretend ignorance of the law. The law is he has to give a return.
You have, as far as the assessment is concerned, you have passed assessment order.
Yes. Thereafter only the dues have.
Where is the assessment order, Mr.
Well, I'll place it. I'll place it.
Give a copy to him.
I'll give a copy to her. Kindly see, my lord, proviso to section 185, my lord. Provided that in case of such determination of valuation, a notice stating the proposed valuation shall be issued to the owner or any lessee, sub-lessee or
Recorded owner.
Of the land. Yes, I am the recorded owner. No such notice has been ever issued.
Very
to
well,
me.
I'll produce it. I'll produce it.
We'll keep it tomorrow, you produce it.
My lord, kindly not tomorrow, my lord,
Tomorrow
then
it
after
will
that.
not be
I have some
possible so far
difficulty,
as
my lord. Kindly,
the
my lord.
records are concerned, my lord, keeps it 2 days or 3 days after the vacation.
After the vacation, the difficulty is I am in the circuit for 2 weeks.
But only the document has to be given to him. I can give the document. Your lordship fixes at week's time after the vacation. I'd be within that week, I'll be giving him the documents. And after your lordship comes back, your lordship will take up the matter.
So then we'll.
But he cannot, my lord, so far as Mr. Chatterjee is concerned, he cannot resist the.
No, I'm not resisting, my lord. I am not resisting. I have come here only for an explanation.
You have already attached it.
My lord,
He is not
yes,
paying to us.
my lord, I am not paying
We have
only
attached-
because
he has not-
the landowner.
He is not
He
honoring
is
that order.
no, my lord, not that, my lord. I am here to get an explanation. Shall I pay? But then I shall pay, my lord.
Explanation is
My lord, land.
I'll decide this one then. Take down. The petitioner in the present writ petition is challenging the notices of attachment of rent issued by respondent municipality towards outstanding property tax qua the premises 2290 Rajaram Mohan Road, Calcutta. Ward number, ward number 123, Calcutta. Raja Ram Mohan Road, ward number so and so, Calcutta. Full stop. It is the case of the petitioner that he is a lessee qua the premises in question and is running a restaurant in the name and style of
Saptapadi.
SAPTAPADI Saptapadi restaurant from the said premises. Full stop. He entered into a 60 months lease agreement commencing from 1/12/2021 to 31/11/2026 for a monthly lease rent of rupees 1,25,000 plus GST along with refundable security deposit of rupees 7,50,000 paid in advance at the time of execution of the lease agreement with respondent number 7, right?
My lord. Respondent number 7.
7. The petitioner received the notice for immediate payment of outstanding dues on 1/8/2024 issued by the Chief Manager Revenue addressed to the respondent number 7, in which it is mentioned that there is an outstanding property tax due of rupees 27,37,309 qua the premises in question, and was asked to pay the same within 7 days. Full stop. The petitioner, by letter dated 6/8/2024, intimated respondent number 7, being the landlord of the said premises, regarding the notices received by him, and requested to make the payment towards the said property tax. Full stop. Respondent number 7, by letter dated 16/8/2024, refused to make the said payment, saying that it is the liability of the lessee to make the payment towards property tax dues. Wide, full stop. Wide letter dated 29/8/2024, petitioner denied the said liability. Full stop. Petitioner subsequently, by letter dated 29/8/2024, requested the Chief Manager (Revenue) and Assessor and Collector borrow 16, right?
Yes, mother.
Borrow 16, KMC, to recover it from the lesser, respondent number 7, full stop. However, without considering the petitioner's reply, respondent municipality issued another notice dated 4/2/2025. Full stop. Issued attachment.
My lord.
They had issued an attachment, right?
Yes, my lord. Yes.
They
Attachment of rent.
issued
Attachment of
notice of attachment dated 11/12/2024, first reminder 11/12/2024, first reminder dated 7/1/2025, and second reminder dated 4/2/2025 were sent to the petitioner. Full stop. Being agreed by the same, the petitioner has preferred the present writ petition. This court has heard the argument advanced by the parties and has perused the documents on record. The petitioner is a lessee qua the said premises in question. Full stop. The tax demand qua the said premises in question is the first-hand responsibility of the owner of the premises. Full stop. Whether the said amount is to be recovered from the lessee or not is depending upon the agreement between the lessor and the lessee. Full stop. However, if the property tax is outstanding qua the said premises, the commissioner is entitled to attach the lease rent by virtue of section 195 read with section 225 of the Calcutta Municipal Corporation Act 1980. Full stop. In the present case, there is an outstanding property tax dues. Full stop. The landlord has not taken any steps to challenge the said property tax assessment or demand for payment of the outstanding dues. Full stop. In these circumstances, the respondent municipality was well within its right to recover the same from the lessee. From the lessee in terms of attachment of his rent under section 195 read with section 225 of the Calcutta Municipal Corporation Act. Full stop. The dispute between the petitioner and the landlord, qua the liability to pay the property tax, is their private dispute, and the same has to be adjudicated in terms of the lease agreement subsisting between the petitioner and his landlord. Full stop. It is noted that there is an arbitration clause in the lease agreement executed between the parties. Full stop. The respondent municipality has nothing to do with the said lease agreement. Full stop. That
But
is
only one, my lord, humble prayer.
yes.
Kindly give me liberty to raise all these points in the proper forum or before arbitration or before civil court, wherever.
Learned counsel for the petitioner is at liberty to raise this issue of
193
property tax either in terms of the lease agreement existing between the landlord and the petitioner, or before any other forum which he chooses to go before. Full stop. In view thereof, this court is of the considered opinion that KMC is well within its right to attach the lease rent, as there is substantial outstanding tax dues, and the same has been done in accordance with Section 185 read with Section 225 of the Calcutta Municipal Corporation Act 1980. Full stop. Since there is no merit in the contention of the petitioner, the present writ petition is dismissed.
Let it be disposed of. My lord,
All
my
right,
lord,
in view of-
193 shows that they have the liability to pay.
In terms of the above direction, the present writ petition is disposed of.
Grateful, my lord.
I'll take your petition. Learned counsel for the petitioner, has filed the present writ petition challenging the what are you seeking?
Sorry, my lord. My lord, I'm very sorry. My lord would kindly pardon my impertinence. Kindly comes to page 17, the prayers.
Yes, that's
what he argues and what the prayers are totally, my lord, divergent.
That's exactly what I'm saying.
Totally divergent.
Yes, sir. What are your prayers?
Prayer B, my lord, I have challenged the attachment of rent, my lord, but
that's covered.
The assessment has not been served upon me, my lord. The revised assessment.
It's nowhere there in the prayers.
Where are you saying that?
That is not there, my lord, but
then, sir, you withdraw this and file a better petition if you really want to do that. I am not going to put words in your mouth. You tell me what you want to do. You have not challenged it.
Yes, my lord, that is there.
So, sir, what do I do? Dismiss it?
No.
There is no
liberty to file a
Learned counsel for the petitioner seeks to withdraw the present writ petition with liberty to take appropriate proceedings in accordance with law.
But liberty to file a fresh petition.
With liberty to take appropriate proceedings in accordance with law.
But he should go before the hearing officer, my lord.
Has to.
He should go to the hearing officer.
Notice has been served upon me ever, my lord. The notice all has.
He should raise objection and attend the hearing.
All the premises make submissions beyond the scope of your prayers.
So that is I am giving you liberty to file in accordance with law.
Grateful, my lord.
Grateful, my lord.
Dismissed as withdrawn with liberty to take appropriate proceedings in accordance with law.
Grateful, grateful.
Week.
22nd, huh?
That's the question.
Two minutes break.
Yes, yes.
coffee break. We'll have it in July.
তাহলে একটু টাইমটা এক্সটেন্ড করো না।
Third July.
There's an interim order, my lord.
There's an interim order here. Stay.
Yes.
But whenever. Only for a short period after the returnable date, my lord. In the meantime,
ভালো করে এক্সেপশন
You have not placed on record the order of the special commissioner with the writ petition.
Special officer, yes, no, I have.
Special officer,
Yes, sir.
18/9/2023. That is one of the objections.
Special officer's order, my lord, is there in the writ petition. Eh? Oh, because they had not given us a copy of it.
No, he was not there.
No, because he was not. No, no, my lord, just one second. My lord, it is not our case, my lord, the proceeding has concluded. This is in connection with Nico House. Corporation could not find out the plans. One of the persons in occupation said that there are no plans. Corporation could only find out plans in respect of a few floors and is looking for the plans for the other floors. All of these are sanctioned. In the midst of the proceeding, suddenly, my lord, an order is made.
This was pasted.
What was pasted, my lord, is at page 43. A notice of engagement telling me that the top floor will be demolished. Top floor is not unauthorized. None of the floors is unauthorized. The corporation itself is looking or collating the plans, looking for the plans to be laid before the special officer. At this stage, suddenly this discriminatory treatment for the top floor, we couldn't understand. We are persons who have purchased from the liquidator. And this is valuable property. I'm not suggesting that a purchase from the liquidator makes it a sanctioned one, but corporation has not come to a finding that these constructions are at all unauthorized. They are all covered by plans.
No, they are, the finding is there. There are two orders which have been passed, A and B.
Yes. Kindly see, my lord, at what stage, my lord, these orders have been passed. Please have a look, my lord, at the orders.
The asbestos shaded structure at roof may be removed, and the second is regarding structural stability.
Yes. So he's kept one part pending and the other part is directed to be removed. None of these parts have been tested against the sanction plan. Proceedings are underway. Qua those structures are not unauthorized structures. They are covered by sanctions which have been called for by the special officer. So he has to adjudicate everything together. Whatever is in whatever part offends the sanction, he can pass an order of demolition. But today, pending further inquiry, he has suddenly decided to remove the structures on the top floor. We are saying why this discrimination. Lord, we respond to your to the report. We Lord, kindly, Lord. Anytime your lordship says, Lord, we can come back.
Since there is stay, then I would keep it on
whenever, my lord, whenever.
27th.
27th. Okay, your lordship.
In the meantime, the interim order is expiring on, Mr. Banerjee?
It's expiring tomorrow. Expiring tomorrow.
The interim order granted earlier by order dated 19th of March 2025 is further extended for a period of 6 weeks.
6 weeks after reopening, Lord? 6 weeks after reopening?
No, 6 weeks today will take care of end of June.
Yes. Covered.
No.
6 weeks. Further for a period of 6 weeks or until further order, whichever is. Sorry, 26. I'm sorry, 26.
26th.
That's a Thursday.
Report time. Okay, নাম দাও ডিসিশন কেন এটা তোমার না 11 I beg to appear on behalf of the petitioner. My lord, this is a case, my lord, that is a protracted history of litigation. Since, my lord, I am trying hard to restore a water body. And lordship will find, my lord, from page 12.
Yes.
My lord, page 12, my lord, the order passed by this honorable court at the very outset.
my lord, directing, my lord, the Kolkata Municipal Corporation to consider the case under section 397 of the Kolkata Municipal Corporation Act, because, my lord, the promoter or, my lord, the owner of that particular building showing the, my lord, pond as a Vastu land obtained sanction building plan. Our case was, it was misrepresentation and fraud. My lord, the Honorable Writ Court was kind enough to direct, my lord, the KMC to look into the issue. Lordship, kindly come to page 9. Second paragraph. Therefore, taking the facts narrated above to be prima facie, the Commissioner of Kolkata.
Wait a minute.
Lordship, got it? Page 9.
Page 9 is the
part of the judgment, my lord, annexure P1. No, my lord, I may be excused, my lord.
Yeah, not
Yes, my lord, the pagination there is page 12, 13, 14.
Yes, that's
It
what I
will be
thought.
14, my lord.
Page 9 is a prayer.
Yes, my lord, yes, my lord.
Yes.
Internal page 3, second paragraph.
Yes.
Therefore, the taking the facts narrated above to be prima facie, the Commissioner of Kolkata Municipal Corporation is directed to invoke section 397. Lordship knows that is for, my lord, recalling of sanction building plans in the event of fraud and misrepresentation is practiced. My lord, the conduct of the KMC, my lord, Lordship cannot, my lord, in all occasion cannot, it is beyond explanation. In this case, my lord, they preferred appeal before the Honorable Court. Page 15, annexure P3. KMC preferred appeal. You know, we have done everything. Though it is relegated to the, my lord, the chief executive officer of the KMC, in spite of that, my lord, they are trying to hide something and, my lord, preferred this appeal. Honorable Division Bench was kind enough to direct the BL and LRO to come back with a specific report. Report says it is a pond. Then, my lord, the appeal of the KMC, my lord, destined to suffer. Lordship will find paragraph page 17. In the light of the above statement as quoted above, we do not notice any palpable infirmity and perversity in the impugned judgment.
Yes.
So then, my lord, what happened? KMC, my lord, page 18,
Yes.
compelled to look into the issue once again by their chief executive officers, CEO, Municipal Commissioner. Page 18. Here, my lord, they have revoked the sanction building plan. Page 20. Then, Lordship, kindly see number of, my lord, the litigation. And, my lord, we pray for implementation. Page 22. And, my lord, there is a specific direction for implementation. Page 24. Then, my lord, kindly see page 25. 554, 556 notice was issued, my lord, to demolish and to restore back to its original position in terms of the Inland Fisheries Act. Then, Lordship, I am drawing Lordship attention, page 30, 31. My lord, I am a tenant in a nearby area, or rather in the vicinity, and one of the court below, in the civil court, page 31, order portion may kindly be looked into. Second line, it is hereby declared that the plaintiff is a tenant in respect of the suit property. The defendant are hereby restrained by an order of permanent injunction from creating disturbance in the peaceful possession of the plaintiff, forcefully evicting the plaintiff from the suit property without due process of law. So, my lord, my right has been protected by the civil court. In spite of knowing all this fact, while implementation of the, my lord, their notice under section 544, 546, my lord, they have demolished my portion instead of restoring the pond standing thereon. My lord, my apprehension was there. My lord, they can do all these things. I have made a prayer before this honorable court. Lordship will find, my lord, my prayer, page 9. Now, my lord, page 9. Page 9, my lord. To be a writ of or in the nature of mandamus declaring the tenanted portion of the petitioner is protected by the civil court's order. Then, my lord, then commanding the respondent authority not to interfere with or demolish the shop room lying at B73.
Mr. Chakravarti, who are you? You are a tenant.
Myself is a tenant.
In which property?
My lord, B73, my lord, Bondipur Road.
B73 is the property.
Here, my lord, I am showing, my lord, Lordship will find. Here, my lord, premises number is, my lord, 138 Bondipur Road, page 25. And this was never the subject matter of demolition.
Wait a minute, Mr. Chakravarti, you were a part of, it's a landlord-tenant dispute.
Landlord-tenant dispute, my lord, they are trying to evict me in their own fashion and way. I was in the civil court protected me. They did not participate in the civil court, expertise, it is protected me. That being the situation. Now, my lord, 5, 4, 46 and 44 and 46, my lord, they have issued notice for, my lord, restoration of the water bodies Once, my lord, the KMC preferred appeal to stop this. Now, my lord, keeping in the mind everything, they have taken revenge and, my lord, demolished my portion without demolishing that portion which was declared by this honorable court a pond and required to be restored. Our humble submission, my lord, the implementation of the order is needed. That is one part. The other part is, my lord, status quo ante I am praying. But in one matter, when the Bombay High Court directed, my lord, status quo ante, and, my lord, there is direction, it was before the Honorable Supreme Court. Supreme Court says, at least compensation is required to be paid. I intend to rely that particular judgment. Let, my lord, my humble submission, I am not praying any interim order. Let KMC authority come forward. My allegation which I have made, whether are true, correct or not, whether they have restored back that particular pond. My lord, we are talking about environment, global warming and everything, and, my lord, drainage and all these things. Whether the authority whose mandatory function is to protect environment, to protect pond of the city of Calcutta, is at all protecting, my lord, they are discharging their own duty. My lord, this question is required to be answered by them. My lord, I have filed one, I intend to file one supplementary affidavit subject to the leave of this honorable court, because after filing this case, honorable court was kind enough to list it. Thereafter, my lord, court took leave, and, my lord, this was not taken up for hearing, no protection available from the High Court, and they have done this mischief which was anticipated and apprehended by us. That is why, my lord, one supplementary affidavit I have prepared. Lordship can accept it, my lord. At the same time, liberty may kindly be given, my lord, to rely upon a judgment passed by the Honorable Supreme Court. May I, my lord, hand over the judgment?
Let me hear. Yes. What is there in the supplementary affidavit?
My lord, supplementary affidavit, notice has been issued at that point of time. I approached this honorable court. My apprehension I have expressed. It was listed, but not taken up. Justice Chandra, court number 15, was on leave, as a result of which this was not taken up. And the date of, my lord, demolition, my apprehension was correct. Because KMC is always in nexus with the promoter, as a result of which, when Writ Court directed to consider the matter under section 397, they have preferred appeal, though it was relegated to them, to their chief executive officer. So, my lord, they are trying to hard. My lord, lordship shall initiate this judgment. Private respondent nexus with the government and instrumentalities. In that case, my lord, the Writ Court, my hands is, my lord, not, my lord. That being the situation, my lord.
Yes.
This is the utterance of every litigant when he comes to court for protection, that the authorities are in league with the other persons, the opponent parties. And if the opponent party comes, he will say with the petitioner. This is the situation we have been facing, my lord, right? But this is the case, your lordship has seen the orders. Now, my lord, he has come now to protect his, my lord, this structure in the premises. The court directed, because, my lord, he was the tenant. Just I'm giving a short picture to your lordship, my lord. He was the tenant before the development of the property. And, my lord, there was an understanding that he will be provided with a certain areas in the after the development of the property. There was, my lord, he was not accepting the proposals of the persons, my lord, the owner of the premises. Then he started a development, develop a situation. He found out a document that his property, my lord, was not, my lord, conversion was not made. In those areas, at one point of time, all the, my lord, the pond, doban, etc. was there. But when the building was there, and he was in the tenant in the said premises, now the owner, my lord, decided to develop the property. There was an understanding with him. Agreement was there. Then, my lord, this, my lord, dispute has arisen between the, regarding the share and the areas of the property. Then he started raising the dispute. Then, my lord, the court ultimately held, so far as that party is concerned, that whatever the structure is there is to be demolished. Now, my lord, if I take that, after that order of the division bench and the municipal commission also took a decision that really, my lord, it was found that the old document is there, that it was at one point it is a pond, but physical position was there, but long back it was, my lord, the solid land. And already the building was there according to our assessment record. But in any event, that we have decided to demolish the structure. Now, the structure not only include the structure which has been, my lord, developed by raising a construction on the sanctioned building plan, the other structures which are in the property, if it is a pond, then, my lord, everything should go. How he could protect his property, the structure? He is saying that my structures to be protected, but the other portions to be demolished. How he could say that? Because it is his own, my lord, the statement before the court, the premises was the pond. If the pond is there, it is the finding. If the court is directed and the municipal commissioner was asked to, my lord, take a decision on that, I have taken the decision. Now, I cannot retain his structure. Therefore, this writ petition is only limited regarding his protection of his structure, whether that could stand or not. After all these things are over, because according to his own statement, the entire the area of the particular premises is a pond.
Yes.
He cannot get any protection.
Yes.
That will be a different issue then. If it remains, then the other party says that the developed property under the sanction should also be remain.
Yes.
This is my limited
But
submission.
I am not asking for any entry model, Lordship, subject to correction. My lord, I am beseeching, let there be a direction, my lord, to file affidavit. My learned friend is, my lord, vociferously, my lord, submitted. We were there, my lord, to restore pond. Let a person be appointed from this honorable court to go there, whether the person who are living on that particular pond is still living, whether the pond is restored.
You are challenging the notice dated 10th of...
No, my lord, the notice dated
10th of March
2025.
25.
That was not covered by my property, but our apprehension was at that point of time, while doing this particular thing,
Yes.
certainly they will demolish my portion because they are aggrieved and dissatisfied, and they are in league with the promoter, and that is why they preferred division bench appeal, my lord. That being the situation, and my apprehension has been, my lord, correctly, my lord, it is found, my lord, correct. Now our humble submission, my lord, whether they have restored, for which 10 years litigations are going on in different division bench, single bench, municipal building tribunal, Kolkata Municipal Corporation.
Wait a minute. If you are, where is that 10th March? You're challenging that, right? Which
My lord,
page?
page 25.
Page 25.
25.
Your contention is that your property is not covered
Yes, my
by
lord.
this notice.
Yes, my lord.
Right?
Yes, my lord. Kindly direct them to produce the demolition sketch and precise whether my property is there or not. While they are in the spot with the notice.
I'm on the different issue. If it is a pond, entire area is pond, therefore not only that, but he is complaining about that structure for which one of the proceeding was initiated because he raised an issue against the gentleman. Now the structure, if they are on that finding, we have passed the order. There is a pond. Therefore the structures to remove. Therefore he can't say only that the while structuring and the restoring the position, if the water body is to be restored, then his structure cannot remain there.
My lord, page 9 may kindly
He will enjoy the property of others.
So you are not an occupant of premises number 138.
No, my page 9 may kindly be looked into B73 Bondipur Road.
Page?
Page 9, my lord. The prayer portion.
So, but today, what are you agreeing with?
My lord, aggrieved by at that point of time when I preferred this writ application, that apprehension was there. I am seeking.
You can't come to the court on apprehension, Mr. Chakravarti.
No, even that apprehension has been, my lord, found correct.
No, but where is the demolition order as far as you are concerned?
My lord, demolition order concerned, I know, my lord, because of they have uttered this, that we are going there and we will demolish your portion first. And that was done, my lord.
On this statement, I can't.
Yeah, has done it, my lord. That is supplementary affidavit, lordship, kindly see. If this honorable court kindly permit me, my lord.
Show me.
I wrote them immediately. Lordship, kindly see.
What is the supplementary?
I'm showing, my lord. I'm showing. You know, in that.
At least you should come. Yeah, you should come clean to the court. You know,
yes, my lord. Certainly,
the
my lord.
impression which you are giving to the court.
Certainly, my lord.
Is that the demolition notice has been passed against your property. That is not correct.
Not correct.
No, but that is not what is reflected from your pleading at all.
My lord, in pleading, my lord, in prayer, I have indicated my portion.
No, but that will not do. You are challenging today.
Yes, my lord.
What are you challenging?
No, today, my lord, to some extent, this particular
apprehension, you can't come to this court.
My lord, the apprehension found correct because I have preferred this writ application prior to taking their action. And my lord, the apprehension was there in that particular writ application that was subsequently, my lord, found correct.
These are all those cases where you are just trying to settle your score with your
my lord,
landlord.
Subject to correction, my lord, that is not. It is found, my lord, as observed by the division bench of this honorable court. It is observed. Yes. Now our humble submission, my lord, I wrote a letter addressed to the my lord complaint regarding unauthorized demolition of KMC. This is a letter addressed to the my lord the police authority, and I have enclosed here with my lord the order of the my lord civil court. and I'm paying rent, my lord, in the rent control. All the documents are there, my lord. Now, my lord, KMC, my lord, let a question may kindly be, my lord, I intend to put this question to myself. Protracted litigation, whether the pond is restored or not. Pond is, the structure is there, and that is
not the subject matter of this
my lord,
litigation.
admitted.
Sir,
Admittedly.
this is not a public interest litigation
No,
you have come here.
true, my lord. Admittedly, in a similar circumstances, lordship, kindly see paragraph 16. Observed by the Supreme Court.
Yes, Mr. Ghosh.
Page 15, page
what,
15.
What is this whole fight between? He is not, there is no cause of action for him.
Yes, my lord.
Mr. Ghosh, just correct
my
me.
lord. My
Before
lord.
you make your submission, just answer
my lord.
pointed queries. Today, he has approached this court regarding the notice issued on 10th of March. The notice is not concerning his plot of land at all, right? He has come to the court on an apprehension that all this will happen.
Lordship.
On apprehension, I am not entertaining this litigation. Is there anything which you are doing right
well,
now?
I'm correcting you, my lord. The premises which is concerning and where, my lord, he is submitting that his structure is there. With respect to that particular premises, he raised an issue before this court that it is a pond, it is to be restored.
Correct.
Therefore, the structure in a plot of land, his structure where he is claiming that it is to be retained.
Also part of that pond.
Part of that plot of land. Therefore, if I demolish, if I proceed, yes. I have given a notice for demolition of the entire structure for restoration of the water body.
Yes.
First stage to demolish.
Yes.
Therefore, he is coming that this part of the building be demolished, my structure be remained. How could there be, in the same plot, his structure, which is, considered to be authorized and also, on a pukur, on a pond?
The two separate premises, my lord, which I have shown. That is why, my lord, I am praying, my lord, let there be an affidavit, my lord, kindly consider.
No need, sir.
My lord, paragraph 15, my lord. Paragraph 16, paragraph 16, my lord. Before passing any order, my lord, paragraph 16 of the, my lord, the judgment which I have handed over, my lord.
Yes.
This is, my lord, civil appeal number 7627 of 2019. My lord, paragraph 16, page 15. We make it clear that we do not approve the action of the municipal corporation or its official in demolishing the structure without following the procedure prescribed by the law. Here, my lord, the same thing. But the relief which has been given, my lord, by the Bombay court must be in accordance with the law and not in violative of the law. If a structure is an illegal structure, even though it has been demolished illegally, such a structure should not be permitted to come up again. If the municipal corporation violates the procedure while demolishing the building, but the structure is totally illegal, some compensation can be awarded, and in all cases where such compensation is awarded, the same should be invariably be recovered from the officials who have acted in violation of the law. Even if it is unauthorized, they should, my lord, adopt a procedure and then to come to a conclusion. It's a separate premise. This is my humble submission.
You can file a separate writ petition seeking compensation for any illegality. That liberty. I don't need to give you that liberty.
So, my lord, since, my lord, this honorable court is adjudicating the previous writ.
So I'm adjudicating because you have come here on a pretext that something is going to happen.
That pretext found correct, my lord.
If
sometime our apprehension also, my lord, subsequently converted to
on apprehension, well, anyway, action has to be taken as far as
after when it is true, became true, my lord, it is no more.
Petitioner has preferred
the
petitioner has preferred the present writ petition seeking protection against imminent demolition action to be initiated by respondent municipality in pursuance of notice dated 10/3/2025, issued by the executive engineer building wide memo number KMC, building, building BR dot 11 Roman 11 -186 -24/25. It is the case of the, और अगर ये समझ में ना आए तो यहाँ से उठाओ. ये ठीक है, page 25 लिखो, take portion. It is the case of the petitioner that he was a tenant in respect of the said building and in respect of asbestos shed shop, right? You have a asbestos shed shop lying and situated on embankment. right?
Yes, my lord, my address is B73 Bondipur Road.
All right. It
That
is
is
the
in
case
page
of the
number 9.
petitioner that he is a tenant in respect of asbestos shed shop lying and situated at the embankment of the pond at B 73 Bondipur Road, Calcutta.
70.
And adjacent to premises number 138 Bandipur Road, Calcutta.
My lord.
Full stop. There is a landlord-tenant dispute which pending between him and his landlord.
But it was disposed of, my lord.
Yes, yes. And TS number?
TS number, my lord. Lordship will find, my lord.
343 of 2024.
Yes, my lord. 342 of 2024.
Was filed before the civil court Alipur
First court Alipur
against his eviction. Full stop. He has been depositing his rent in the court of additional rent controller Alipur. Full stop. He filed writ petition WP2 4444 of 2014 against the cancellation of the building sanction plan for the premises of his landlord, i.e. premises number 138, Bandipur Road, Calcutta. And at his instance, BLNRO passed an order dated 4/1/2018 cancelling the building sanction issued for the premises number 138, Bandipur Road, Calcutta. Full stop. Again, he had approached this court in WPA number 20480 of 2018 for demolition of the said premises. And at his instance, the executive engineer building had passed an order dated 8/10/2025 initiating the process of demolition of the said building. Full stop. Now the petitioner is apprehending that the KMC officials in connivance with his landlord will demolish his tenanted premises. This is your apprehension, sir?
At that point of time when I have filed it.
Yes. It is his submission that he had earlier also filed TS number 342 of 2014 in which the court had granted an ex parte order dated 14/9/2014 restraining the defendants from obstructing the peaceful possession of the petitioner and also evicting the petitioner from the said property without following due process of law. In view thereof, the petitioner is seeking protection against the demolition of his tenanted premises. This court has heard the argument advanced by the petitioner and has examined the documents on record. The entire process has been initiated at the instance of the petitioner who was settling his personal score with his landlord. The entire demolition notice which has been issued on 10/3/2025 has been initiated on behalf of the petitioner who was trying to settle his score with his landlord. It is only at his instance that the executive engineer building has passed the order dated 10/3/2025, initiating the process initiating the process of demolition of the unauthorized structure at 138 Bandipur Road, Calcutta. Full stop. It is the case of the petitioner that his premises is different from the landlord's premises and hence not covered by the action initiated by the respondent municipality. This court fails to understand that since the petitioner is residing in a different property and the notice dated 10/3/2025 is not related to the petitioner, on mere apprehension, the present writ petition is being filed. Full stop. Though is being filed. Full stop. In the facts of the present writ petition, this court does not wish to exercise its discretionary jurisdiction under section 226 on a mere apprehension that the petitioner's property, which is not part of the impugned notice dated 10/3/2025, should be entertained. In the petitioner has in view of the said fact, the present writ petition is dismissed. Anything else, Mr. You have to, any submission?
No, my lord, I will take action, my lord, as the court, earlier the coordinate bench directed, and also in terms of the order of the municipal commissioner.
My lord, the liberty may kindly be given.
For what?
For taking appropriate action in appropriate forum. Otherwise, my lord, someone will raise the question, my lord, this is a res judicata and all these things, my lord. To avoid all this, my lord, kindly one line order may kindly.
For what, Mr.
My lord, because of, my lord, one may take this question that this was a similar issue ventilated previously, and my lord, there was no such,
This notice,
lordship,
on the face of it,
lordship,
is not covering your property.
True, my lord, one line. One line.
Liberty will, any liberty is available to you if they take any action.
True, my lord. One line may avoid future complication. That is why I am beseeching.
What future
That is
complication?
that is why I am
Come to
beseeching.
this court only on
My
the
lord, my
basis.
learned friend cannot say anything. It is in between myself and my prayer before this honorable court.
Yes,
My
yes,
learned friend
absolutely.
cannot say anything.
No, there's no need for that.
If no need, my lord, that is a different question. My learned friend cannot stand.
If this
He
notice
is always
had-
standing with the promoter, my lord. That being the situation, he should not stand on the way.
So you were also there earlier.
On some occasion, that is
The
the
same
question
thing-
of.
Same thing people can say about.
No, that is the only question of our earning bread, my lord. Ensuring that is why. Otherwise, not. My learned friend case is different.
May I make one humble submission out of this, my lord, case, my lord, that if you will say, because the only Thursday, I understand, my lord, the division bench taking up the appeal matters, my lord, public interest litigation, both original appellate side. I am to be there, my lord, most of the time. This is the first time they started. If you will change after the vacation, change the dates, my lord, day from Thursday to Wednesday, my lord, it should be, my lord, otherwise, my lord, I'll be difficult to assist your lordship, my lord.
We'll consider that. We can do it.
My lord.
That's not a,
Instead of Thursday to Wednesday, my lord.
we can do it.
Yes, we can.
And Mr. Ghosh, just ensure, I didn't want to say that, but
My lord.
if you are taking any action against his property, follow the due process of law.
Yes, yes, of course.
Please, Your Lordship. My application, the grievance of the petitioners is to do with the failure of the corporation authorities to take follow-up steps after issuance of a 411 notice. Now, the premises is situated in Shambajar Street, one of the busiest parts of North Calcutta. It is almost 150 years old. Now, notice was issued in the month of May 2024 under 411(1), well, identifying that certain portions of the building require repair works and some portions well, need to be demolished and renovated afresh. Now, well, after this notice was issued, the petitioner well, engaged a structural engineer empaneled with the corporation authorities to inspect the building and to prepare a report. That report was prepared. Well, observations are well, that this building has run out of its serviceability period. Well, the beams and iron and well, brick and mortar structures are so old and are so withered, well, they are no longer capable of well, holding the structure together. We communicate well, this report to the corporation authorities by letter saying that, look, this is a 150-year-old building. It cannot be repaired in the manner well, suggested by the corporation. And moreover, well, there are numerous tenants. Well, it is fully occupied by, not, I shouldn't use the word tenants, well, by occupants, who according to us are unauthorized. Well, we also inform them about this and say that please take steps because I am well, at a loss. I do not know which way to go. Corporation says nothing doing. We are sorry, but we have issued you a notice. You comply with that. Well, therefore, well, this application, if your lordship kindly takes well, the structural engineer's report, well, that is at page 22.
Page 22.
Yes, well, page 22. Rupak Kumar Boshak. Well, this report is dated 10th February 2025. Lordship kindly comes straight away to the observations at page 28. I'm just placing very quickly. From the overall inspection of the building, it is evident that the building has exhausted the serviceability period. That is, it has crossed its lifespan. Building seems to be more than 150 years old and has not been properly maintained for a long time. Supporting MBs, which are the beams, are entirely corroded. It has turned into iron oxide. Material property of iron has been lost. Hence, it has lost its load-bearing capacity too. Then, this last sentence of this page, due to corrosion of steel displacement, results in the shifting of masonry materials. Masonry elements are peeling and falling off. Well, photographs are also annexed. Then kindly comes to page 30. This is one of these old structures where they use kodi borgas, which are the wooden beams. Kindly sees picture 9 is given of the damaged kodi borgas where they're completely falling off. Then when it writes the mortar of the supporting load-bearing walls carry no strength. Material properties of shurki, bricks, earthen tiles, and steel are lost. It has absorbed moisture over a long period of time and has lost its structural integrity. Now, thereafter, last sentence again, deflection of structural members and floors has caused several portions severely damaged and susceptible to fall at any time. But again, next page, it is a photograph of the building. Your lordship will see there are vegetation coming out of the walls even. That is again recorded at page 32. That there are roots which have deeply penetrated the walls and it has caused water seepage and crumbling of mortar. The final conclusion your lordship will find at page 36, where the structural engineer says that it is impossible to repair the building as it stands. It has to be fully demolished and be constructed afresh. Your lordship will kindly take the penultimate, the last 3 paragraphs. Building has exhausted its lifespan and cannot be repaired or restored. Any attempts to repair or insertion of any supporting members will cause collapse of the building. The building is dilapidated. Building should be entirely vacated and is to be demolished as early as possible to prevent any damage to passers-by and inhabitants of the building. Now, the very next page is my communication to the corporation, also enclosing a copy of this report. The second paragraph, I have narrated the circumstances in which this report was prepared. And thereafter, I say additionally, the property is presently occupied by unauthorized individuals. We kindly urge you to take necessary steps to address this situation. Now, kindly sees the corporation's reply.
I have got an instruction.
At page 39.
Yes.
The second paragraph, however, it is to be mentioned that a notice under section 411(1) of KMC Act has been served to the owners and occupiers. And also, this portion is very important. I'll show your lordship the provisions of the law. A caution board for dangerous building has already been affixed on the wall of the premises to alert the inhabitants as well as the general public. The reason why I lay emphasis on this expression that the corporation has used is the follow-up to 411 would perhaps be 412. But if your lordship kindly takes the act for a moment, what I'm really seeking is assistance to do with vacation of the building. Because there are at least 14 occupants who have arrayed as private respondents number 7 to 20. Your lordship will kindly see what the act envisages. 411 is the notice. Even 411 subsection 4B, if your lordship sees. For B, in any such case, the municipal commissioner may cause the inmates of the building to be summarily removed from the same or such portion thereof as he may consider necessary. Now, it kindly sees 412. The municipal commissioner may, by order in writing, direct that any building which in his opinion is in a dangerous condition or is not provided with sufficient means of egress in case of fire or is occupied in contravention of section so and so be vacated forthwith or within such period as may be specified in the order. Now, even 412 capital A is important because this was introduced by an amendment of 2017 to take care of very similar situations where buildings are dangerous but are completely inhabited by occupants and tenants. We'll kindly see 412A. Yes.
Which is that section which deals with the tenants?
But this is my instruction I have got. Notice under 411(1) has been issued. But the prayer of the petitioner is B, directing to consider and dispose of written representation February 28, 2025.
That is the alternative prayer, right?
Yes, alternative prayer is there. You have made that prayer. I have to read it. You have not expunged that.
By principal prayer, your lordship will see prayer A.
This is almost similar to page 39.
We have issued that notice. Now, my lord, so far as the prayer is concerned, we will consider their representation regarding that which they have prayed for, and we will pass the reasoned order regarding that, because the inmates that are there, that is the problem is this. This is the main problem.
This is the main problem.
Main problem.
And Mr. Banerjee knows it very well.
No, my lord knows more than me.
No, not at all.
Fact
I'm
is
learning.
that inmates, they could not remove them. Wants to
I'm learning from you,
build a
Mr.
multi-storied building, they cannot remove them. Now they are coming with that. In any manner,
They have to rehabilitate them.
Yes. They have to be rehabilitated. So in that case, my lord, if your lordships, because under 412(2), there is a prayer. If any person fails to vacate the building in pursuance of such order, the municipal corporation may direct the police over that we can do to remove, because that is
They have to be
412(2) that is there.
Rehabilitation will
cannot find this way of removing tenants.
No, 412 capital A, Roman 3. There is a
We can
provision for
only do
rehabilitation.
that much and nothing else than that. But fact is this, now the provision is
Oh, you
that
tell me that that provision where they have to rehabilitate.
Yes, but it's Roman 3 of 412 capital A, kindly sees.
rehabilitation. That is, my lord, at 412A3.
Yes.
A3. May I read on?
Yes, yes.
Simultaneously with the making of the declaration under clause 2, the corporation will serve a notice upon the owner or occupiers, as the case may be, and paste it on the outdoor of the building, providing an option to the owners or as the case may be of the building to reconstruct a building according to the plan to be sanctioned by the corporation with such expedition as possible, and providing for maximum floor area necessary for accommodating the erstwhile occupiers as the case may be, and additional floors as may be required for recovery of the expenses for construction after relaxation of the applicable building rules. In the event the owners, as the case may be, so agreeing and applying, the corporation shall allow a building plan submitted for the purpose to be sanctioned with additional floors and floor areas so as to provide for the recovery of the expenses to be incurred. This is the provision, Madam. Again, in the event of disagreement or disinclination on the part of the owners, as the case may be, to avail the opportunity contemplated under clause 3, the owners, as the case may be, keeping the building in a dilapidated condition which may likely cause the environmental pollution, fire hazards, unsafe to public safety, health hazards, nuisance, etc. shall be subject to such action as provided in the law for the time being in force.
Right, I'm sorry, but I stand corrected. 412 subsection 3, if your lordship also says.
Yes, I have read it.
That's what he read, sir.
412 subsection 3.
No, but 412 capital
Yeah,
A. 412 minute. This
That
minute
I
provides
read
for
before.
reinstatement.
Provided further that if the occupier shifts somewhere else to facilitate the process of development work, they will be provided the certificate of occupancy under provision of the corporation. Last line. Roman 5, the last, provided.
Roman 5. করেছি।
You have to provide them a temporary shed also there. We have done that in.
Yes.
There is one more provision.
In Howrah also, we have done.
Which provision? There was another 500 or something which you had quoted. Where before the sanction plan, they have to take the consent of all the tenants and rehab.
Yes. My lord, yes. In the Howrah Corporation, that is building rules.
Building rules.
Building rules, man.
Yes. Which section was that? 500 something.
Building rules.
For all occupants. All occupants. ये judgment का देखो परिचित हो
Single type. Single type. বিল্ডিং রুলস ছিল না বিল্ডিং রুলস আছে এখানে আছে না এখানে আছে সেখানে বলেছিল আমরা একটা শিফটিং করতে পারবো সেটা আমি হাওড়াতে করেছিলাম একটা কলকাতার মধ্যে বিল্ডিং রুলস করেছিলাম এই রুলস
I was carrying a division bench of our court. A similar set of circumstances, 412 capital A steps were directed to be taken and a clarification was given for reinstatement of the occupants in the newly constructed building.
No, there is a building for shifting the. Yeah, I have done that matter. The Howrah case.
I remember we.
Yes, I have done that. My lord, may take it up tomorrow. I can come with the.
And 412 subsection 3, actually the design, may I be permitted. There is 411, my lord, here the petitioner also come to this court after purchasing of the property, it's a ploy for actually evicting the tenant. Straight away, my lord, I am submitting this. If your lordship actually, that is 411, that is the subjective satisfaction of the municipal commissioner when we are actually thinking, or my lord, that is for the dangerous part, we demolish or actually directed. My lord, if you lordship kindly then take 411, after that, my lord, 412, power to order building to be vacated in certain circumstances. May I read it for your lordship?
Which provision? Mr.
412, section 412.
Yes.
Municipal commissioner may by order in writing direct that any building which is in his opinion is in a dangerous condition or is not provided with sufficient means of egress, etc., be vacated forthwith within such period, and provided that at the time of making such order, municipal commissioner record a brief statement of reasons. My lord, subsection 2, if your lordship take, when I actually recourse actually taken regarding section 412, straight away tremendous dangerous inhabitant have been actually removed, and thereafter, my lord, subsection 2, if any person fails to vacate, I remove them. My lord, then, my lord, if your lordship take subsection 3 of 412, the municipal commissioner shall, on the application of any person who has vacated or has been removed from any building in pursuance of any order or any direction, as the case may be, under this section, reinstate such person in the building as soon as the circumstances permit. Have you also got it? That is reinstatement. 412 if recourse.
Yes.
My lord, here why I am actually telling you lordship, submitting before your lordship 411.1. My lord, 2-3 years back, the petitioner purchased the property and there are so many tenants he cannot control. He is not taking any steps. Everything actually on the shoulder of corporation.
Right.
And we are responsible. My lord, that is depends upon my judgment that building will fall upon or not fall upon. Now the petitioner come your lordship, before your lordship, praying for actually taking some order from this high court and demolish the building. There are so many tenants.
Correct.
That is a real problem.
They have to be rehabilitated.
They have to be, and my lord, if your lordship is thereafter kind enough to take that is section 400 capital A, there the whole scheme is there. And my lord, my lord senior actually referring 412A,
Yes.
there the provision for how the petitioner will approach the corporation, not to say if your lordship the entire that order has been passed 412A
Yes.
regarding there, my lord, everything is there. My lord, that is the petitioner actually failed.
3 and 4 I have
My
read.
lord, you have already read. That
3,
is
4,
there, my
5
lord.
also. 5 is also relevant.
3 and 4, my lord,
3
substitution.
and 4 I have read.
Yes. 5 is
I
also
have read
relevant.
5.
5.
Now,
My lord, that is 5 is
but
actually
one,
not feasible.
section 12A1 is there. Issue a notice to the owner and also occupier, recorded as such in records of the corporation, calling upon them to show cause. That is there. Within such period as may be prescribed. Why the building in question or any portion thereof shall not be declared to be condemned for the purpose of this section. And after hearing the causes shown within the said period or such further period as may be granted, man has got it.
Yes.
That is one.
Yes.
If it is found necessary in public interest to declare the building or any portion thereof condemned and should be demolished immediately for public safety,
Yes.
the declaration may be made
12
to that effect, requiring the building of or the specified portion thereof to be demolished. But this is there. But what the commissioner will do, but they have made a prayer. Second prayer is there. There's many things we have to do. They have to do. That my learned junior also was specifying. The alternative to the respondent authorities, that is at page 18, be directed to consider and dispose of the detailed representation dated 28 February 2025 in accordance with law. Now, we shall dispose it of and we will specify what things to be done, how shifting should be done. Thereafter, my lord, if they are agreed, then they can come again.
May I suggest this? My lord, instead
It's
of
not complete as well.
instead of disposing of my representation, my learned friend has correctly said 412 capital A is a complete scheme. It starts with issuance of a show cause notice. All parties have an opportunity of being present, being heard. There is a declaration that is to be issued. There is also a provision for accommodating the erstwhile occupiers.
When you're asking for evacuation.
Well, I'm asking, let the 412
Yes,
capital A
that
recourse
cannot
be
be
taken.
done. It can't be taken, sir, till the time the commissioner is not satisfied.
Your lordship has seen page 39.
I've
That
seen
is
page
satisfaction.
30. That is not satisfaction at all. What will happen to the tenants?
Well, they are to be rehabilitated.
So who will rehabilitate them?
Well, it will be done by the owner.
Where is the undertaking to that effect?
Well, I'll give an undertaking. Well, there's no difficulty at all.
There is no pleading.
Well, I have said so in my petition also. Well, there is no difficulty in.
Where is that? Huh?
No pleading is.
Where is that?
Where they will be given alternative. Let them know. I think no pleading is there to that effect.
Where is that, sir?
No pleading is there. I have seen.
On the contrary, my lord, these are methods of evacuating or evicting your tenants through a circuitous route.
Your lordship will
illegally.
Your lordship will direct me. I'll give a written undertaking before court. Well, there's no difficulty.
I don't need to direct it. You have to do it in accordance with the.
I'll do it before the corporation authorities.
For that reason, I'm saying
the contrary, record my submission. Well, on instructions, I'm making my
7 to 18, my lord. My lord, on the contrary, my lord, in page 37, petitioner has framed the private respondent as unauthorized individuals, my lord. My lord, one lordship has showed enough mercy regarding the occupancy of the private respondents, my lord. Only one thing, my lord, one last thing, my lord. Kindly consider running page 28. The report itself says that the building seems to be more than 150 years old and has not been properly maintained for a long time.
Yes.
So the owners or predecessors of the owners did not maintain the property. For that reason, we can't be homeless. Whether we are occupants, bona fide, or we are trespassers, that is subject matter to the civil code, my lord. And lastly, my lord, in running page 36, this report, the last line, my lord, this report is based on visual inspection, observations, and experience only, and not on any testing or laboratory procedure.
Yes. There is no question.
But you have to specify. You have to pass an order.
They have to pass an order regarding that they have prayed for rightly in the second part.
Yes.
So we will pass that order.
Have to pass
But
an
so
order.
far as evacuation, we cannot say something. We cannot say anything.
No, evacuation, you can't even get it done.
I cannot.
Till you follow the due process of law, you
I
can't
will
evacuate.
follow as fallen from your lordships, 412A.
412.
Read with 412 itself.
Yes. So you file your report, put it on record.
As your lordships, we can.
Or you can do one thing. You don't press for prayer A. I'll dispose it of in terms of the
Consider and
representation.
dispose of my representation.
412A.
Very well, your lordship disposes according to prayer B.
Take down. Learned counsel for the petitioner restricts his
report
writ petition to prayer B of the present writ petition. The petitioner seeks disposal of his representation dated February 28, 2025, filed before the. Where is the representation?
Well, it is at page 40.
40. Filed before the Calcutta Municipal Corporation. Learned counsel for the Calcutta Municipal Corporation, Mr. Sandeepan Banerjee, states that they are ready and willing to decide petitioner's representation dated 28th February 2025 in accordance with law. First, in view of the statement made by the respondent, petitioner states that he shall be satisfied if the same is decided in a time-bound manner. Full stop. In view of respondent number 5 shall be decided by respondent number 5. In view of the said statement made by the parties, this court directs respondent number 5 to decide petitioner's representation dated February 28, 2025 within 8 weeks. Within 8 weeks from the date of communication of this order, after affording an opportunity of personal hearing to the petitioner as well as the private respondents or any other stakeholders. Full stop. Stakeholders by way of a speaking order. With the above direction, the presented petition is disposed of.
The report that was handed over, shall
There's nothing in the report. It's exactly what it is.
Only one.
I'm not even keeping it on record. I'm not keeping it on.
Second time is sitting also.
Yes.
There's division bench.
There's a division bench, but I'll come back after the because just 2 days. So
after the division bench?
After.
May the affidavit of service be kept.
Affidavit of service is taken on record.
After.
Yes.
Lordship, I'm aware this is not the time of mentioning.
Not at all.
If your Lordship permits me.
No mentioning right now.
Very well, Lordship.
I will appear on behalf of the respondents in the matter.
Yes.
I'm for the petitioner.
Yes.
The counsel engaged in this matter is just on his way.
You can start.
Yes.
Open the brief.
Yes, yes.
Read the prayer clause. Yes, you have read the brief.
Yes, yes.
Assist.
Your Lordship, the petitioner has made an application before the corporation for cancellation of a mutation in respect of a property of which we are the owner. We have made representation on 12/11/2022. Hearing notices were thereafter given to us on 2 occasions, that is on 12th November 2022 and 1st December 2022. We attended the hearing, we submitted our written notes of arguments, and thereafter it was kept for passing of necessary orders. 2 years have passed, and till date there is no orders in respect to the hearing conducted. We are only seeking for direction upon the KMC to pass necessary orders.
You appear for KMC?
I am for the private respondent. I am not for KMC. We have private respondent.
Who's for KMC?
But KMC is not appearing, and only one thing, most humbly.
KMC was there in the first half.
Miss Sen, where's your senior? Miss Sen, where's your senior? I'm asking you, madam. Who you are for KMC? Seek instruction, we'll keep it tomorrow. All right. Simple point. They are saying that hearing has been given. No final order has been passed. Your junior did a good job. Your junior did a good job.
Great, Lordship.
You have trained him well. So basically a final order needs to be passed. Just find out when will they pass the final order, or they have passed or not passed.
My lord.
So
Can I give a copy of the petition?
Yes, give a copy of the petition.
Your Lordship, object to your Lordship's correction, my lord.
First one,
With keeping it tomorrow.
Gopal Das.
For instruction, yes. Wait a minute.
Lordship, Mr. Gopal Das was already appearing for the KMC. Yes. Seen him with the brief right here.
Oh, where were you? What is the instruction?
Education.
As your Lordship has already been apprised, it's a simple matter.
That can direct the KMC authority to come to a conclusion.
So, who's the
probably this is the prayer.
Your senior is
That
there
is
in
very
this
much the
matter.
prayer.
Pass over. Call him. Find out what is the status. We'll decide it. Thank you, Mr. We'll pass over. Pass over.
Yes, Your Lordship.
I'm for the private respondent. I'm
14
led by
November,
Mr. S. P. Mukherjee. Is appearing virtually.
14 Millard, I appear for the petitioner. Now, my lord, this is a case, my lord, where there has been history of litigation and counter litigation. Now, my lord, in both the cases, my lord, a common order was passed by this honorable court directing the Kolkata Municipal Corporation to initiate proceedings under section 400 subsection 1 of the Kolkata Municipal Corporation Act. Now, my lord, the order is at page 20 of the writ petition. May I place the order before your lordship? Page 20 of the writ petition.
Yes.
Both these writ petitions are being heard together, as the petitioners in each case have made allegations of unauthorized construction against one another. The first writ petition, WPO 678 of 2024, pertains to a construction at premises number 173 Barik Molla Lane, ward number 137, police station Metia Bhuj, while WPA number 21603 of 2024 involves a construction at premises number R216B Cotton Mill Lane within the same ward of the Kolkata Municipal Corporation. The corporation has submitted two separate reports regarding both premises. These reports indicate the presence of unauthorized construction at each site. Additionally, the report suggests that stop work notices under Section 401 of the Kolkata Municipal Corporation Act 1980 have already been issued for both premises. The corporation has also initiated proceedings under Section 400 of the Kolkata Municipal Corporation Act 1980. Considering the nature of the allegations in these writ petitions, I am of the view that the corporation should proceed with the further actions under Section 400, subsection 1 of the Kolkata Municipal Corporation Act 1980 by providing due notice to the individuals responsible for the unauthorized construction. The corporation is directed to complete these proceedings within 3 months from the date of this order in accordance with law. Now, that being the order, but in this backdrop, there are allegations of further construction on their behalf. Lord, I have annexed the next page. Your Lordship will find at page 22. It appears, my Lord, no proceedings has been initiated thereafter. My Lord, we were to receive notices if the hearing was to be conducted before the special officer building of the Kolkata Municipal Corporation. Well, they are making further construction. I have annexed the photograph and I have made a complaint to that effect to the Kolkata Municipal Corporation. Well, apparently, my Lord, this stop work notice has been issued in respect of premises number R173 Barik Molla Lane.
In both the matters I appeared, but regarding this matter, my lord, no copy has been come to me and officers directed me to appear. I don't know he served the.
I have served, my lord, evidence of services on
in
record.
the first order I was there in the takedown. Matter was.
This is the second round of litigation. This court, while earlier order dated. This is the second round of litigation. This court earlier wide common order dated 15 January 2025 passed in WPO number 678 of 2024 and WPA number 21603 of 2024 directed the respondent municipality to act in accordance with section 400 of the KMC Act and complete the proceedings within a period of 3 months, full stop. It is the grievance of the petitioner that despite such a direction, the private respondents are carrying on with unauthorized construction in the said property, full stop. Learned counsel for the respondent, for एक और line. The petitioner has made a representation dated 19/2/2025, bringing on record the said unauthorized construction. However, till date, no action has been taken by the respondent corporation, full stop. Learned counsel for the respondent seeks and is granted.
My lord,
I'm for the private respondent.
sir, regarding this, both the petitioners and respondent are actually committed illegal construction. They are
know that order records
that
itself.
order is also recorded there.
Then you have to proceed under section 400, pass a demolition order,
Lordship.
bring it to a logical end, demolish both the properties.
Lordship, dispose of the matter or the matter will come back after?
You report. What is your?
My lord, I think I should need some report from the authorities what they are doing.
Learned counsel for the respondent, Calcutta Municipal Corporation seeks and is granted 4 weeks time to file his report by way of an affidavit. Reply to the same, if any, within 1 week thereafter. Let this matter be listed after 6 weeks.
Only one copy may be served upon me.
I shall serve, no problem. In the course of the day.
I'm not recording it. I'm taking you on your face value.
But I'll serve just.
6 weeks. Date देखो 6 weeks. 3rd July.
But Lordship can record, Lord, I am serving here and now.
3rd July.
But I've served the copy in terms of Lordship's instructions.
3rd July. Lordship, 3rd July.
Should I record that?
I received the copy, Lordship.
Actually, the matter will appear on
Copy
3rd
of
July.
the writ petition is learned counsel for the respondent states that he was not served with a copy of the writ petition. The same has been done in the court. The respondent has been served with a copy of the writ petition. और उसके बाद कर देना, he seeks and is granted.
My lord, regarding item number 13, my junior.
Much obliged.
Yes, call out 13.
I am here, my lord. 13.
Yes, call out 13. Call out 13.
My lord, without entering into the matter, my lord, may I submit one thing? The matter will be disposed of.
Yes.
Because my lord, that is corporation authorities, my lord, at that point of time took hearing regarding a mutation.
What happened to the?
And thereafter, my lord, 2 years passed away. The officer, 2-3 officers changed. After 3 years, they come before your lordship for passing of an order. I suggest, my lord, that I will they pass the order. My lord, certain time may be given, and if necessary, I will call them for one time. An order will be passed as per your lordship.
The petitioner has referred the present writ petition being aggrieved by the inaction on part of the respondent authorities in not passing any final order qua the proceedings initiated by the respondent at the instance of the petitioner herein for cancellation of cancelling the mutation of the petitioner's mutation of
38 by 1A, Ustad Inayat Khan Avenue.
petitioners. You are asking for cancellation of mutation of
38 and 38 by 1. Premises numbers 38
respondents.
of the private respondents.
Of the private respondents' property.
Your Lordship,
property number 38 and 38A.
38 by 1.
Lordship, we
Capital
take
A.
claim of the property. So if your Lordship would merely confine it to the premises numbers. If your Lordship records that it's the private respondent's property, then we may be in some trouble.
Private
Because
respondents.
there are two
premises
civil
number.
suits which are pending, my lord. Sorry.
Private respondents premises number 38 and 38A.
38 oblique 1A, Ustad.
Oblique 1A, Ustad Inayat Khan Avenue.
Yes, your Lordship.
Ward number 64, Borough,
7.
Borough 7, Calcutta. Granted in favor of respondent number 5 to 19.
Yes, your Lordship.
Right? It is a case of the petitioner that he is the co-owner of the premises in question. Full stop. However, he
Your
came
Lordship,
to
we said that we are owners of the premises, that they have no ownership.
Then, my lord, I have to dispute it, my lord, because there are civil suits which.
put your dispute. Learned counsel for the petitioner states that he is the owner of the premises in question. However, he came to know that the respondent municipality has mutated the property in favor of the private respondents number 5 to 19. Petitioner preferred representations on the representation, and on the said basis, hearing was conducted on 12/11/2022 and 1/12/2022. However, no decision has been taken. No decision has been taken. Petitioner, learned counsel for the private respondent, refutes the said allegation and states that there are pending civil suits between the parties wherein the question of ownership of the said property is under adjudication. Yes, full stop. Learned counsel for the respondent municipality states that they shall pass a speaking order that states that they have already conducted the hearing as per the hearing, which is also reflected as per the submission of the learned counsel for the petitioner. Though no final order has been passed, learned counsel for the respondent municipality ensures that the final order in terms of the hearing conducted on 12/11/2022 and 1/12/2022 shall be passed within a period of
Within a period of, my lord, 2 months.
within a
Because there is
period of
for another document.
within a period of 8 weeks. With the above said direction, the present writ petition is disposed of.
My lord, your lordship will be pleased enough to record, my lord.
Affidavit of service is taken on record.
My lord, since affidavits are not.
If all likely, this court has not entered into the civil disputes between the parties. This court has not expressed any opinion on the civil disputes pending between the parties.
Yes, your Lordship.
Now take the those special assigned matters. Not supplementary. Who's appearing for?
My lord, I appear for the petition.
Have you served them?
Yes, my lord. I have
Where are
served.
they?
My lord, this is my affidavit of service.
Affidavit of service will not do, madam. You have to call somebody.
This is my notice after mentioning.
Where are they? Who's appearing, Mr. Naik? You're appearing? Who's appearing for Calcutta Municipal Corporation?
Item 15.
No. It was a supplementary.
But I am not.
Supplementary. You are appearing, Mr. Das?
One matter is given.
Which one,
WPO
Mr.
379.
Number is not there. Momita.
It is second.
That is the second matter. I'm sorry.
This is item number 1. He's appearing in item number 2, my lord. I have
Who's in
given
item number
notice.
1?
They have received, my lord. They said
Can you take the second matter and first matter? Mr. Ghosh will be called upon.
Mr. Ghosh is coming? Okay, second matter. Pass over. First matter. Second matter.
Kindly see, in terms of an earlier order of a writ court on the basis of a complaint of a person, corporation was directed to conduct a hearing after inspection. Well, your lordship will come to page 28. This is the order in the earlier writ petition.
Yes.
Lordship will kindly come to the second page, page 29. Writ petition is disposed of, directing respondent number 4 to consider and dispose of the representation after given opportunity of hearing to all necessary, including the petitioner. Pass a reasoned order, communicate the same. A spot inspection shall be conducted to ascertain the nature and extent. Then kindly seize, my lord, page 31. This is the notice of joint inspection. I did not get any report thereafter. I have specifically pleaded in paragraph 7. What is the charge that I must know after inspection? Then, my lord, kindly see page 32. This is a notice of hearing to be convened on 18th November. But I had prayed only for one adjournment by the next letter at page 33. Thereafter, my lord, I did not receive any further notice of hearing. My lord, if your lordship sees my pleading, kindly come to paragraph 12. Then, my lord, I have given a representation on 21st November. I have said, my lord, that there are some internal partition walls which you may kindly regularize. This is page 35. But I have said, my lord, kindly see paragraph 12, that thereafter I was never served with any notice of hearing. I have made another representation at page 36. There, of course, my lord, I shall be candid enough that that particular fact is not mentioned in the second representation at page 36 regarding the no notice of hearing. Ultimately, my lord, only day before yesterday at night, this notice at page 52 has been affixed, where they say that they will come today morning for the purpose of demolition of unauthorized construction by order dated 14 December 2024. No, here I have not been given an opportunity of hearing. I do not know what is the inspection report. I do not know what is the order. My specific pleading, your lordship will get paragraph 7, that no inspection report has been given to me. Page 5, para 7, and paragraph 12. That after 21st November 2024 representation, I have not been served by any further notice of hearing. And page 52, this is the notice affixed day before yesterday at night.
Para which para?
Para 12
and para 7.
And para 7.
Para 7? The para 7, there's nothing. No report.
Yes, no report, no inspection report.
and para 12 at page 7. Neither the petitioner nor her co-sharer was served with any further notice of hearing by respondent number 1/5 till date.
Yes, Mr.
My lord, in short, my lord, in this matter, Sandeepan Banerjee is actually a leader of mine. But the thing remains, my lord, I called upon the officer and 2 extra floors are there and demolition work is going on. My lord, that part is not actually submitted. That is actually order, my lord, order, my lord, my lord, my lord. Order, my lord, order is passed under section 408. If your lordship, the 2 floor extra and demolition process is going on. Now, my lord, I actually asked them to actually go to
You have to give them a hearing.
Yes.
There is
My
a
lord,
direction passed by this
that
court.
direction, my lord, that direction passed. And Mr.
So the records, my lord, that they have
In
given.
terms of the direction, you have to give them hearing.
I understand, my lord. I have actually read this order passed by Justice Sinha, and that part, my lord, that hearing was given. My lord, what happened, my lord? These 3 months time, the time is very short actually to take exact instruction from my officers who are engaged in demolition for 2 extra floors. My lord, the last, if you is kindly, my lord, I understand. My lord, page 29. If you is kindly take page 29.
Yes.
My last paragraph. My lord, this is no explanation regarding the previous paragraph. My last paragraph, may I read for your lordship? It is made clear that this court has not entered into the merits of the claim made by the petitioner. All points are left open to be decided by the aforesaid respondent.
Yes.
My lord, I am bang upon this, my lord. I may be excused regarding this because, my lord, at that point of time, just his representation for regularization. Now, corporation, my lord, in line and toto, the order has not been followed. I agree with your lordship. No doubt about this. But, my lord, just visualize a situation when the authority take up the matter and seen that 2-3 extra floors have been done, then, my lord, 408 validly passed.
That's all right.
My lord, my lord, he has the instruction regarding.
Immediate instructions are very difficult.
I know, Mr. Banerjee, but demolition matter going on, get demolition. That's what the allegation.
It has been served.
He says no notice has been served, nothing has been served. Otherwise, I am not interested in unauthorized construction. You know it. Law will take its own course. Anything which is,
My lord,
If they produce the notice of hearing, if they produce the order, I will go out.
so far as the notice is concerned, that notice, probably I cannot get that whether the notice has been served or not. If the notice is not served, then they would have get 30 days time. That is there. So only 15 minutes I will ask them.
ask,
served upon them.
ask them and give them the demolition order. They'll challenge it.
Yes.
But if they have not given me any hearing, then, my lord, I am that demolition order.
Find out if you have given a notice or not.
No inspection.
One
report.
notice was given.
Let it be kept after the just 1 week after the vacation.
Let it be state. My lord.
Then don't carry out the.
State. Today is we will not demolish them.
Yes, that is what I'm saying. That is what I'm saying. State is that.
Don't carry on the demolition.
As well.
That's what they want. I don't want to
What
stay.
else? What else?
I don't want to stay it, Mr.
I
Banerjee.
don't want to also I try to demolish. But I
If
have
you
to
come
take
back
some
in 15 minutes, we'll see that.
15 minutes if your lordship says, then I can ask them.
Ask them. I'll pass it over. One matter more I have passed over.
No, but there are one more issue is there. The order, before the order, I must be served with a notice.
Let's see if they are served or not. That's
Yes.
what he's saying.
Yes.
10 minutes, I'm coming.
Very well. As my learned friend submitted demolition, that should not go on. That demolition work should not go on, my lord. Otherwise, my lord.
10 minutes, Mr. Sane. 10 minutes.
না না স্যার আমি বলেছি যখন বলেছি যে কোর্টের কাছে
Pass over.
the demolition team is there.
Very well.
They have not
Very
taken
well.
any-
Very well. That is okay. That is sufficient.
Pass over. Mr. Ghosh is here.
Yes, sir.
Item 1.
One, my lord, I appear for the petitioners.
Yes, Mr. Ghosh.
My lord, his junior is here, my lord. I took time on behalf of Mr.
Who? Miss.
Given the brief along with Mr.
Yes, sir.
My lord, may I
Yes,
just place
yes,
the
madam.
case? My lord,
Just
this
a
is
minute, yes.
third litigation pertaining to the same school, La Martiniere. May I just briefly indicate the facts, my lord? La Martiniere school was established in 1936, very old school, my lord, and it has been classified as a grade 1 heritage building. So that means I cannot even touch the building without taking permission of the concerned respondents.
Yes.
Now, Lordship, I have made several representations wherein I have prayed for my building to be delisted from such list of grade 1 heritage building. They have not taken any steps. Writ is pending. In the meanwhile, this year, early part of this year, the respondent has issued a notice to the local police station stating that I have defaced the building. Although repair work had been stopped pursuant to a 401 notice, they wrote a letter stating that I am defacing a heritage building and immediate criminal proceeding should be initiated against me under section 425p of the KMC Act. I filed another writ petition challenging it. Lordship kindly takes up the order passed by this honorable court, which is at page 50. After taking everything into consideration, this honorable court has passed 2 orders of injunction, one upon the respondent from taking any coercive steps against me, and one on me, injuncting me from undertaking any repairing or any civil work of whatsoever nature at the subject heritage premises without consultation with the appropriate authority of KMC. Now, my lord, I have written umpteen number of letters and representations to KMC, to the commission, that kindly give us permission to make necessary repair work, only repair work for conservation and heritage of the heritage building, because it is a school, my lord. At the end of the day, students are going there, and the roof, I have shown Lordship in the morning the pictures, the roof is falling, the staircase almost on the verge of collapsing. So Lordship kindly takes up, I'll just show my first representation, page 53, my lord kindly takes up. 53, Lordship, a detailed comprehensive representation was made based on the liberty given to me by the honorable court that you make a representation if you want to carry out any civil work. Kindly takes up page 56. I have detailed the proposed works, that renovation, flooring, electrical work, sanitation, toilet renovation, renovation of administrative block, painting work, removal of old structures and roof repair. Without this, Lordship, how am I supposed to carry on administering a school, that to La Martiniere for boys and girls, both schools, my lord? They did not take any steps on that. And Lordship, vacation is ongoing. The school has closed on 16th of May. It is supposed to reopen on 12th of June. This is the only time I have, my lord, to carry out any repair work. Also, Lordship, may I just indicate, I had engaged an architect who took inspection of the whole building, and he himself has written a letter stating that these particular renovation work can be carried out without defacing or damaging the entire building. I have again reiterated my prayers before the KMC, before the commission, time and again, February, March, repeatedly repeating my request, ki allow me. You and also Lordship, the KMC has come to the premises. They have conducted inspections several times, even a couple of days back on 6th of May, 16th of May. Yet for reasons unknown, they refuse to grant me any permission, any sanction. A school, my lord. Children will be rejoining on 12th of June. And Lordship, as per section 425A, the occupier has a statutory duty to conserve, restore, and protect a heritage building.
Have you got a permission from the Heritage Committee?
I have written letters. Everybody is sitting tight on my representations.
Heritage Committee a party here?
Yes, my lord, I made him a party. Yes. And they have been served, my lord.
They are not here, madam. And obviously, I can't allow the petition on the first day.
We have served, Lordship.
Can't help you.
Lordship will appreciate the urgency in the matter, my lord.
Can't help you.
Lordship, may I serve them in the course of this day and come back tomorrow, my lord, if Lordship so permits?
These are heritage buildings.
We have served a notice after mentioning as well, my lord. After Lordship allowed my mentioning, I've served a notice on them. And Lordship, they've come to my premises. And
on 16th, it has been inspected. The building has been inspected, and it is found what they have stated here. They have want to for permission. They pay for permission for this construction. They have completed that.
We have not. We have not touched, my lord.
They
have not
after
touched.
obtaining the order from the court of stay order was passed by this honorable court. Thereafter, they have to do all the works.
We have not, my lord.
Done.
We have not
It
touched.
has been found. So far, I have obtained the instruction.
Then they should have filed a contempt before the Lordship. I'm sorry, my lord.
I have obtained the instruction from my officers concerned over telephone that it has been inspected on 16th, and it is found that they have completed the works.
what they have asked for. This is the position, my lord.
My lord, kindly takes up page 116.
Take down. The petitioner has preferred the present writ petition. The present writ petition has been taken up on mentioning. Full stop. The petitioner has preferred the present writ petition, seeking repair and restoration work at the premises. What are these two schools, right?
La Martiniere School for girls and La Martiniere School for boys.
At the La Martiniere School for boys and girls, situated at, what is the holding number?
Yes, my lord.
Holding number you have not
Holding number
at,
is
situated at UN
11 Dr. UN Brahmachari Street
Holding
and
number
14
11.
Sarojini Naidu Sarani.
Holding number 11 and 14 UN Brahmachari Street and
My lord,
14
11
Sarojini Naidu
yes.
Sarani Saini. What is it? Sarani, Calcutta respectively. It is the case of the petitioner that repair and renovation work is needed and that there are cracks developing in the said building. Since this building is a heritage building, the necessary permission has to be sought from the West Bengal Heritage Commission before undertaking any work. Full stop. Learned counsel for the Calcutta Municipal Corporation, who appears on notice, states that he has received instructions from his engineer, from the area engineer concerned, and states that the petitioner has carried out repair and renovation work without seeking any permission from the West Bengal Municipal, what is that? West Bengal Heritage Commission. Full stop. The same fact is disputed by learned counsel for the petitioner, who states that they have not carried out any repair and renovation in the above mentioned premises. Full stop. Let a report be filed by the learned counsel for the respondent corporation within a period of 2 weeks. 2 weeks.
After vacation.
Reply to the same, if any, within 1 week thereafter. Issue notice to this. No one appears. There's no appearance on behalf of, which is respondent number?
Respondent number 6, my lord. My lord, despite notice, my lord.
Respondent number 6. Respondent number 6. Full stop. The petitioner shall serve them afresh. Full stop. Upon service, the respondent number 6 is directed to file their report by way of an affidavit within a period of 2 weeks. Reply, if any, thereafter. Within one week?
1 week.
Within 1 week, list after 4 weeks.
My lord, in the meantime.
In the meantime, nothing. This is not your house.
No,
Please understand.
it's a school. That is the only predicament, my lord. The
What can I do? You know how this is. This is a heritage building. It's not only a school.
lordship.
If it's a normal, ordinary school, I can still ask them to do something.
Lordship.
But here the heritage committee is involved. Till the time you don't get a permission from them, they can't allow you to do anything.
Okay.
The order is also very clear to that
My
effect.
lord, I am instructed that there was an NOC given by the commission in 2017.
Sorry, madam, you see the orders which have been passed by this.
Yes, Lordship.
You are aware of the orders passed.
I bow
Just
down,
see
my
Justice Roy's order.
It is only the situation at.
What is Justice Roy's order?
Yes, Lordship. I bow down, my lord.
You know those observations.
If they can come over, take inspection, whatever they say
They can do nothing.
in their supervision. my
Till the time, madam, the permission doesn't come, Calcutta Municipal Corporation can't give you any permission. First and foremost is your NOC, which is required from the Building Heritage Committee, and then subsequently they can grant you permission to repair.
Lordship. As your lordship directs.
Yes.
Deeply obliged. my lord.
Next. Take that original side matter. Yes, Mr.
But they have prayed for an adjournment, but thereafter we have passed expertly. That is the problem.
They were there. At the
By notice, we had asked for an adjournment.
On medical ground.
Kindly see page 33 on medical ground. Thereafter, no notice of hearing was received after this. So your lordship will direct them to conduct the hearing afresh. Give me the inspection report. I will make my submissions, and whatever order will be passed will be passed.
Take down. The petitioner has preferred the present writ petition challenging the impugned notice dated 20th/5/2024-25 issued under section 544 and 546 of the Calcutta Municipal Corporation Act. Issued Calcutta by the respondent number 5 for execution of an order dated 14/12/2024 in respect of the property number 3A Cholpati Lane, PS, Belagata, Calcutta. Full stop.
14 February December যেটা বার করেছিল ওটাতে
Who was that complainant? Pranab Kumar.
He had filed a writ petition, Pranab Kumar Datta. Page 28. On his writ petition, the direction was passed for hearing me.
This is the second round of litigation for the said property. For the said property.
Spot inspection হয়েছে? Spot inspection করেছে?
A complaint was filed. A writ petition was filed by a writ petition WPA number 1570 of 2024 was filed by one Mr. Pranab Kumar Datta alleging illegal and unauthorized construction raised by the petitioner herein. He had filed against you, right?
Yes.
Petitioner herein. Full stop. There was a direction which was passed by this court by in the said writ petition. There was a direction which was passed by this court on 30th/4/2024.
On the basis of that
30th/4/2024, wherein the respondent number 4, being the executive engineer building, Borough 3, was to consider and dispose of the representation made by the said petitioner strictly in accordance with law after giving an opportunity of hearing to all the necessary parties, including the petitioner bracket में डाल देना complainant within a period of 3 months from the date of communication of the said.
Spot inspection was also directed to be done.
The order further recorded that a spot inspection shall also be conducted to ascertain the nature and extent of unauthorized construction. Learned Counsel, the petitioner states that a notice was issued.
But a spot inspection was done, but no report was given. At page 31.
A notice was issued for spot inspection on 3/9/24, right?
Yes.
On 3/9/2024. but no report of the on-spot inspection was given to the petitioner. Further, the petitioner was also given notice on 11/11/2024 to attend the hearing in terms of the directions passed by the Honorable High Court by order dated 34/2024 on 18/11/2024 at 2 p.m. at the Chamber of Executive Engineer Building. Full stop.
And I had
petitioner states that he had sent a letter dated 16/11/2024 seeking adjournment on the ground that the petitioner was unwell and had also attached a medical certificate and requested for another date of hearing. Full stop. Petitioner states that to his utter surprise, he has been served with a demolition notice dated, what is this date? 22nd
20th of May, 20th of
2025,
which has been affixed on the premises.
served so and so, which had 2025, which has been affixed on his property, which reflects that a demolition order has been passed on 14/12/2024 under section 401 of the KMC Act. Petitioner states that without complying with the direction of this court in the earlier writ petition number 1570 of 2024, wherein it was expedient to the respondent to have granted an opportunity of hearing to the petitioner, the said order of demolition dated 14/12/2024 has been passed without affording an opportunity of hearing to the petitioner. Full stop. Learned counsel for the respondent municipality. Yes, Mr. Banerjee, what do you have to say?
I have to say only one thing, that when we will give a hearing, we will submit a copy of the report also. Because again, they will come for the report.
Mr. Banerjee states that they are ready and willing to grant an opportunity of hearing
for the last time
to the petitioner on, give a date, we'll send them.
Any day.
Grant an opportunity of hearing to the petitioner on 28th of May.
My lord.
28 May.
28 May hearing.
At 1 p.m. 1 p.m. my lord.
At 1 p.m. at the Chamber of Executive Engineer Building, Borough 3 at 109 Maulana Abdul Kalam Azad Sarani, Calcutta.
When a copy of the report will also be served upon them.
Yes, well, kindly provided in advance.
Learned counsel for the learned counsel for the respondent shall also provide a copy of the on-spot inspection to the petitioner at the time of the hearing. Full stop. Needless to state, after conducting the hearing, the respondent shall pass a speaking order within a period of
4 weeks, madam.
Within a period of 4 weeks thereafter. Full stop. It is made clear that no notice of hearing shall be served upon
And
the
date and
petitioner.
and the date and time fixed is
They are-
peremptory and mandatory.
They are directed. They are
Instead of
directed.
28th, make it 29th. Well, it's a
They are
vacation day in Calcutta High Court.
directed to appear on 29th of May as per the direction of this court.
The date and time fixed is peremptory and mandatory.
Yes, yes.
At
No
the,
time can be
at
taken.
the prescribed, at the above mentioned date and time.
Only one indulgence.
1 p.m.
The demolition order dated so and so. I'll set it aside.
Yes,
Yes, sir. The dated 14/12/2024 is set aside. Full stop.
And when the notice should be quashed also.
The demolition goes, notice goes.
They are already there. I am told, kindly ask them.
Demolition order dated so and so, as well
But
as
damage done, nothing to do.
the notice in pursuance of the demolition order is also set aside.
They should not, my learned friend should communicate immediately.
I don't know how much damage is done, my lord.
No, but still,
I can assure that
Sir, I
from
will claim
this
damages. I will
moment,
claim
they will
damages.
immediately leave. That I can assure.
The above,
Already I have told not.
with the above,
Only one thing, my lord, only one indulgence, my lord. Instead of learned counsel for the respondent will, because we will not be there, vacation is there. So let the executive engineer communicate the said report, my lord. My lord has indicated that learned counsel
at the
for
time
the.
of hearing, this on
Oh,
spot.
what?
At the time of hearing, the report shall be.
But the
With the
report, I must have a report. Otherwise,
নেই। আপনারা জানেন ওটা।
They will give you
নেই,
one
কিছু
more
নেই।
date. What's the big deal?
Nothing is there, my lord. There is.
It's a case of a lift room. I will show your lordship from the plan that there is a lift room.
They are well aware about it. They can immediately read it there and
Demolition, they don't go.
4 weeks, extended to 8 weeks.
3 weeks.
That's better.
My lord.
You know,
But more importantly, let my learned
Let
friend
that be 8
communicate
weeks.
immediately the
with the above
demolition.
directions, the present petition is
It will be stopped immediately.
disposed of.
Already ভেঙে দিয়েছে হয়তো তাদের।
ভেঙে না আমি যখন বললাম জজ সাহেব নিচ্ছে আমি মানে
Obliged.
আমি বন্ধ করে
Obliged.
when the matter has been heard out we have stopped it. We have stopped the demolition immediately.
Yes.
But disposed of.
Yes, writ petition.
हाँ वो बोले हाँ दिएছি appellate side there is one especially.
May I permit you to mention one leave malar maybe
Thank you
granted.
very much, sir. Not at
I'll be for vacation base malar.
sorry, sir.
Kindly malar.
Not at this time, sir. Mentioning tomorrow morning. Mr. Bhattacharya, you also want to mention something?
No, I have item number. Led by Mr. Kaur.
I thought I was surprised. I would have fell off my chair if I would have seen you mentioning at 3:14.
Okay. Prior to the vacation, every time should be mentioning time.
My lord, no other ordinance matter, lord.
Come where? Mr. What is this? You are the leader of the bar.
No,
huh? Mr. Carr is leader of the bar.
Mr. Kaur.
Mr. Kaur, tell me.
My lord, Mr. Chokro.
Is his statement right?
Absolutely right. And in fact, I full-heartedly support your lordship. Matters in which he is there, looking at him, people will know the weight of the matter.
Absolutely. Yes.
I have a matter in court number 11. I'm going.
He has just shown his face.
No, you can't leave. How can you leave? May I please your lordship?
I'm appearing for respondent number 1 to 5.
All the judgments. Judgments. Yes.
That respondent number 1 has floated a tender.
Your father respondent?
1 to 5, lordship.
Yes.
And there is another respondent, RVNL, lordship.
Who are the tendering authority?
Yes. 1 to 5 is the tendering authority. Respondent number 6, my lord, is an L1 bidder. We have served, my lord, the respondent number 6.
Yes.
Lord, the respondent number 1, Lord, has floated a tender. The scope of the work, your lordships will get at page 55. The scope of the work, in short, is installation of 10 new stations. page 55, your lordships will find this is the work. 10 new stations and Lord, all infrastructure relating thereto. Now, Lord, the completion period, estimated cost of the work, these are all Lord there in the chart. Second and third, your lordships will find.
This is at Chhattisgarh.
This is Chhattisgarh. Lord.
Chhattisgarh.
Chhattisgarh. And the authorities are at Delhi. All the respondents are at Delhi. And
Yes.
But if my learned friend is taking a point of jurisdiction, Lord, let her
because that exclusive jurisdiction is with Delhi.
kindly
Kindly
permit
come
her
at,
to take that point. So
kindly,
that Lord, I meet that point and then Lord, I
kindly
come.
come at page number 138, Lordship.
What?
138, Lordship.
138.
Yes.
The contract shall be governed by the laws in force in India and jurisdiction of courts shall be New Delhi only in exclusion of other courts.
No, where are you reading? 138?
138, page number 138.
Clause 16.
Clause 16. The contract shall be governed by the laws in force. Okay. Yes.
And the Lordship kindly come at para 5 of their petition, Lordship. Your petitioner states that your petitioners, being one of the renowned company in signaling and telecommunication work throughout the India, have participated in the aforementioned tender from its register office at Calcutta by submitting all its documents in terms of the eligibility criteria as mentioned in the clause 3.0 read with annexure 5 from its registered office at Calcutta mentioned above. Lordship, their registered office, they have, that is why they are saying their cause of action lies here. And Lordship, another paragraph, Lordship, para 30. The petitioner states that the tender was published on the website of the government procure system and the petitioner came across the said tender from the website afresh in its computer located at its register office, Lordship. 23A Netaji Subhash Bose Road, Kolkata 7,01,000 within the jurisdiction of this honorable court. The technical bid and the financial bid of the petitioner was signed and uploaded by the petitioner from the register office within the jurisdiction. Lordship, it's their jurisdiction. The entire work took place at Chhattisgarh. All the respondents are at Delhi, and in the special condition of contract, as I have shown, Lordship, in page 138, there is specific bar that the exclusive jurisdiction will lie with New Delhi. Lordship, may I read the entire paragraph? Within the jurisdiction of this honorable court, the technical summary and the financial summary published by the respondent tendering authority has been opened by this petition 30 at the register office within the jurisdiction of this honorable court.
So the only thing which they have done is they have uploaded it from Calcutta.
Uploaded from that. Only uploading, Lordship, and they are attracting this jurisdiction of this court.
Downloaded the tender at Calcutta, uploaded the tender at Calcutta.
Downloaded the tender, and Lordship, in this regard, I have a case law, Lordship, if Lordship, may I place it?
No, oh, sorry.
Yeah. Okay, 99.
Citation about
yes.
Monu TN 3650. TN. Monu. Monu TN 3650 2011. W. Manu আমি শেয়ার করে দিচ্ছি স্যার এক্ষুনি
No, ঠিক আছে just go ahead.
share
Sorry.
আমি শেয়ার করে দিচ্ছি স্যার এক্ষুনি
Sagar RR India.
আমি শেয়ার করে I'm sharing with my landlord senior friend.
Go ahead.
He is senior in all respect. I have learned everything from him. Lordship,
Yes.
কি বলছো দাদা?
Which paragraph?
Lordship, kindly come at page para 13. As the respondent raised the para 13 preliminary objection.
What are the facts of this case?
Lordship, here from the uploading was done from the jurisdiction.
Just read the facts.
Then may I go as per the
Yes,
head
just
note,
read
Lordship.
few
First
lines of.
respondent announced that the last date of submission of document, I'm going as per the head note, Lordship. For current tender on its e-binding website was closed and given copy of circular regarding amendment made in the banning procedures and consequence of termination clause. Thus, the petitioner requested to leave ban or imposed erroneously on them and allow the petitioner requested to lift ban order imposed erroneously on them and to participate in the current tender by first respondent. Hence, this petition, where the court had jurisdiction to entertain writ petition as cause of action had not arisen within the jurisdiction of the High Court, held petitioner mainly claimed attraction of jurisdiction of High Court.
Just read para 6, man.
Mr. G. Masilmani, senior advocate counsel, senior counsel appearing for the respondent raised a preliminary objection on the ground of lack of jurisdiction to entertain the writ petition filed by the petitioner. Mr. V.D. Gopalan, learned senior counsel appearing for the petitioner, has put forward the following contention. The tender, number 8, the tender was downloaded by the petitioner from a website at the petitioner's office at Chennai, which comes well within the jurisdiction of this court, and the tender fee of rupees 45,000 is also paid at Chennai through online. Number B, the respondent's branch office is also located at Chennai. At all communication correspondence addressed to the respondents by the petitioner as written from Chennai, and invariably all communication from the respondents were addressed to the petitioner's address at Chennai and were received by the petitioners at Chennai. Number C, the current tender dated 18/2/2011 floated by the first respondent itself is a e-binding process where the procurement of the tender documents and submission of the document were all made online by the first respondent, and as such, no particular jurisdiction can be confined to such an e-binding process. Number D, the access to the tender document is not open to all, but only on allocation of password and payment of the required fees by the first respondent. The petitioner has received the allotment of password from the first respondent via email and received the same at Chennai on 3/3/2011. E, a division bench of this court has held in 2006 1 CTC 732 X RECT MPA Madurai Vinan numbers such and such, KV Union of India, represented by its Secretary to Government, Minister of Defense, New Delhi, and others, referring to the decision of the Honorable Appeals Court reported in Manu SC 0759 1994, 1994 4 SCC 711 ONGC versus Utpal Kumar Basu and others, that a liberal view should be taken on the question of jurisdiction. Lordship, in this regard, Lordship, may I continue?
Yes.
While determining the cause of action, one has to consider whether such facts constitute a material, essential, or integral part of this cause of action. Even if small fraction of the cause of action arises within the jurisdiction of the particular court, the court would have a territorial jurisdiction to entertain the petition. The prayer in this writ petition is twofold. One is...
You can read from para 13 now.
Lordship,
para 13 onward.
13, I'm citing Lordship 13. As the respondent raised the preliminary objection, 13, Lordship. of lack of jurisdiction, and the learned senior counsel appearing for both the sides have argued at length on that aspect. It is desirable for the court to consider that the said question before considering the submission made on the merits of this case. The petitioner claimed, 14 Lordship, that the cause of action had arisen within the jurisdiction of this court on the following grounds. Lordship, they have again ABC, they have just the grounds which I have already submitted, Lordship, and the next is page number, paragraph number 15. On the other hand, the respondents mainly contended that the above said grounds relied on by the petitioner are not sufficient to attract the jurisdiction of this court. The respondent placed reliance on the tender documents which are binding on the parties at the courts at Mumbai, Lordship. Here the Mumbai jurisdiction was there, was agreed between them. The tender itself was floated from Mumbai by the respondent. It is also floated from Delhi, Lordship. The learned senior counsel appearing on the respondent heavily placed reliance on the decision of ONGC case, reported in Manu SC 0759 1994, 1994 SCC 71 cited Supra, and Alchemist case reported in Manu SC 1290 of 2007, 2007-11 SCC 355 cited Supra. Lordship, then I am relying on paragraph number 19, Lordship. The principle laid down by the Honorable Apex Court in the decision cited Supra is squarely applicable to the fact of the instant case, as in this case also, as the fact remains that the petitioner mainly claimed the attraction of the jurisdiction of this court on the basis of downloading the tender document through website from Chennai. I am making payment of rupees 45,000 through online payment from Chennai, and coupled with correspondence and communication, including the show cause notice sent by the respondents and received by the petitioner, and as well as the communication and the reply sent by the respondent and to petitioner to respondent from Chennai. It is pertinent to note that in the above decision cited Supra rendered by the Honorable Apex Court, reliance was placed on reading the advertisement published in the Times of India at Calcutta, and the tender was made from Calcutta, but the said contention was not accepted by the Honorable Apex Court, holding that the above said factor would not constitute fact forming an integral part of the cause of action. Likewise, in the instant case, the petitioner reliance on downloading and of the tender document from website at the petitioner's office at Chennai, and further the allotment of the password from the first respondent via email was received at Chennai, and thereafter the tender fee of rupees 45,000 was paid through online at Chennai. It is needless to state that a person sitting in any part of the world can very well download of the tender document through the website and procure the tender document and submit the same by receiving the allotment of password and pay the tender fees through online. And on the ground, he cannot claim the attraction of jurisdiction of a particular cause. As far as the case on hand is concerned, the tender was floated from Mumbai and the other process had taken place at Mumbai, and ultimately the respondent rejected the petitioner claim from Mumbai. Apart from the above factor, it is pertinent to note that as per clause 26 of the tender document, exclusive jurisdiction of the Indian courts at Mumbai was agreed by both the parties, and as such, the same is binding on the petitioner. And Lordship, next is para 22, Lordship. এটা পড়ে নিয়ে শেয়ার করে দিচ্ছে সাথে। The Honorable Apex Court in the decision cited Supra also further held that the facts pleaded by the appellant company therein as narrated in paragraph 8 of the decision cannot be said to be an essential material or integral fact so as to constitute a part of cause of action within the meaning of Article 226 Clause 2 of the Constitution. The petitioner herein placed reliance on the similar facts as relied on by the appellant therein. At the risk of repetition, it is to be stated that as far as the case on hand is concerned, the petitioner has pointed out earlier placed reliance on the facts that the tender was downloaded at the petitioner office at Chennai, and the tender fee was rupees 45,000 was paid through the online payment, and the show cause notice was issued by the respondent to the petitioner at the petitioner office at Chennai, and all the main correspondence and the communication between the petitioner and the respondents were made to and from Chennai. if the said pleading and the fact is tested with the touchstone of the principle laid down by the Honorable Apex Court in the decision cited supra, then this court has no difficulty to come to the conclusion that the said facts which have been pleaded and relied on by the petitioner here, it cannot be said to be an essential material or integral factor as to constitute a part of the cause of action.
Yes.
Lordship, 2.5. Lordship,
Yes, ma'am.
Lordship, my next case law is Lordship. National Textiles Corporation. Lordship, here is the same case, Lordship. They have uploaded the tender document from Calcutta, Lordship, only. And now they are
1994 one.
yeah, Lordship.
1994.
1990.
Nico.
And next is National Textile Corporation Limited and other versus 2004 9 SCC 786. Lordship, may I? I'm led by Mr. Ronald.
Therefore, the earlier decision, as has already been cited by Mr. Bhomik, which says that each and every fact which has been pleaded in the petition cannot constitute an integral part of the cause of action. A fact to be decisively said to be a part of cause of action has to be some bearing with the right which are accruing. So under that particular case, which is in my respectful submission, in our respectful submission, squarely covers the fact that merely because they have uploaded the tender from Calcutta, all the authorities under Delhi and the work is at Chhattisgarh, having the contract with the exclusive jurisdiction clause cannot be violated. Now, similar proposition has been laid down in 2004 9 SCC 786. That is a Supreme Court judgment, that is National Textile Corporation Limited and others versus Haribucks Swalram. Now, here in this case,
Yes.
Paragraph 10, under clause 2 of Article 226, which says, that is against me, but I will place this particular portion also. Under clause 2 of Article 226 of the Constitution, the High Court is empowered to issue writs, orders, or directions to any government authority or person exercising jurisdiction in relation to the territories within which the cause of action wholly or in part arises for the exercise of such power. Notwithstanding that the seat of such government or authority or the residence of such person is not within those territories. Cause of action as understood in the civil proceedings means every fact which, if traversed, would be necessary for the plaintiff to prove in order to support his right to a judgment of the court. To put it in the different way, it is the bundle of facts which, taken with the law applicable to them, gives the plaintiff a right to relief against the defendant. In Union of India versus Adani Exports, in the context of Article 226(2) of the Constitution, it has been explained that each and every fact pleaded in the writ petition does not ipso facto lead to the conclusion that those facts give rise to cause of action within the court's territorial jurisdiction, unless those facts pleaded are such which have a nexus or relevance with the lease that is involved in the case. Facts which have no bearing with the lease or dispute involved in the case do not give rise to a cause of action so as to confer the territorial jurisdiction of the court. Milord, pausing here for a moment, Milord. In the present writ petition, what the petitioner has done, they are basically challenging the credential of RVNL.
who happened to be who has come out to be the L1
I
candidate.
had not addressed your lordship on merit yet. It was only on regard to jurisdiction
Reading,
that.
on the reading of matter only I am saying. So that particular thing they have challenged. On merit, I have an answer to that also. I will come to later on when Mr. For submits on that. So next, Milord, paragraph 11, Milord. The again, Milord, Oil and Natural Gas Commission case has been, Milord, as was earlier judgment also followed. The question of jurisdiction was considered in detail in Oil and Natural Gas Corporation versus Utpal Kumar Basu, and it was held that merely because the writ petitioner submitted the tender and made representation from Calcutta in response to an advertisement inviting tender, which were to be considered at New Delhi, and the work was to be performed as Gujarat, and also received replies to the fax messages at Calcutta, could not constitute facts forming an integral part of the cause of action. It was further held that the High Court could not assume jurisdiction on the ground that the writ petitioner resides and carries on business from the registered office address at State of West Bengal in Calcutta. Next, note 12.1, in the same page. As discussed earlier, the mere fact that the writ petitioner carries on business at Calcutta or that reply of the correspondence is made, it was received from Calcutta, is not the integral part of the cause of action, and therefore the Calcutta High Court had no jurisdiction to entertain the writ petition, and the view of to the contrary taken by the division bench cannot be sustained. In this particular case, single bench has said that it has no jurisdiction. The judgment was assailed in division bench said no, there is a jurisdiction. And that was became assailed in Supreme Court. Supreme Court set aside the division bench judgment and restored the single bench judgment.
Yes.
Now, paragraph 18, if your lordship takes. For that reason mentioned above, we are of the opinion that the writ petition filed by the respondent herein was wholly devoid of merit, and the same was rightly dismissed by the learned single judge of the High Court. The appeal is accordingly allowed. The judgment and order of the division bench is set aside, and the learned single bench is restored. The appellant will be entitled to the cost and such and such. So, in this particular judgment also, the same thing happened, that merely because a tender was submitted, merely their office is located within the jurisdiction of Calcutta, that will not form the part of cause of action or integral part of cause of action. Therefore, that is the point on jurisdiction, which my learned senior friend may reply on that. Thereafter, I have answered in fact also, to cut short, fact
But let me deal with this jurisdictional point first. Please, Lord, come to page 138, sorry. Lord, clause 16, on which my learned friend has relied upon, it says the contract shall be governed by laws in force in India, and jurisdiction of court shall be New Delhi only in exclusion of the other courts. Now, Lord, we are not at the stage of entering into the contract yet. We are at the realm of a contract, where, Lord, the first submission of mine would be that this governing contract clause would not come into operation. And I'll cite a judgment also that there is no formal contract entered into between any of the parties yet. This is only, Lord, at the offer and acceptance stage. Now, Lord, question of jurisdiction, it is well settled now that, Lord, the powers of a 226 court cannot be, Lord, curtailed or scuttled by a private contract between the two parties. Even if this jurisdiction clause remains, even then it does not, Lord, scuttle the jurisdiction of Article 226 of a writ court. Cause of action, Lord, I'll deal separately. But, Lord, insofar as the jurisdiction of a high court is concerned,
yes,
Lord, 226 jurisdiction, which is, Lord, comes through the Constitution. Two private parties by contract cannot, Lord, scuttle this. For that, Lord, I just want to cite one judgment, which is reported in 2020, volume 13, SCC, page 285. Please come to paragraph, sorry. paragraph 9. Here, what happened, Lord, a writ petition was filed before the Bombay High Court. Bombay High Court rejected the writ petition on the ground there is a jurisdiction clause in the contract. There was an existing contract or existing bylaws of the association, Chess Association or some other Maharashtra Chess Association. In the bylaws, there was a jurisdiction clause, and that conferred jurisdiction in the Madras High Court. So, Lord, the writ petition was moved in the Bombay High Court and it got dismissed. Lord, please come to paragraph 9. It is well settled principles of contract law that parties cannot by contract exclude the jurisdiction of all courts. Such a contract would constitute an agreement in restraint of legal proceedings and contravene section 28 of the Contract Act. However, where parties to a contract confer jurisdiction on one amongst multiple courts having proper jurisdiction to the exclusion of all other courts, the parties cannot be said to have ousted the jurisdiction of all courts. Such a contract is valid and will bind the parties to a civil action. This principles was set out in ABC Laminat, so and so. And then, Lord, ABC Laminat is quoted. This is, Lord, with regard to a civil action. Yes. Then, Lord, please come to, after the quotation, please come to paragraph 10. Lord, when there is a suit, Lord,
that's a different.
No, Lord, the issue is that by a contractual clause containing jurisdiction, one is, Lord, cause of action. I'll come to the cause of action later. But I'm saying by entering into a jurisdiction clause, two private parties cannot oust the jurisdiction of a 226 court.
See, today there are no two private parties here.
Two private parties.
See, today it is a contract. It's a tender which is being floated.
Correct.
And as far as the tender is concerned, there's no contract which has been entered into as of today.
Correct.
Right?
So therefore, Lord, this jurisdiction clause.
You can argue that also, but at the same time, you have to see that where is
the cause of action. So, Lord, this is only on the question of jurisdiction. That is my first point, that without a contract having come into effect, that clause is not operative at all. My second contention is, even if it is assumed to have come into effect, even then, Lord, if that contract would not be a bar for your lordships to entertain this writ petition. And as for this judgment, your lordships may kindly see paragraph 11 of the judgment. Articles 226(1) of the Constitution confers on High Courts the power to issue writs and consequently the jurisdiction to entertain action. The text of Article 227 provides that the High Court may issue writs for the enforcement of the fundamental rights or for any other purpose. A citizen may seek out the writ jurisdiction of the High Court not only in cases where her fundamental right may be infringed, but much wider array of situations. Lord Coke commented. Then, Lord, please come to the next page. Paragraph 13, your lordships may kindly take note of. The role of the High Court under Constitution is crucial to ensuring the rule of law throughout its territorial jurisdiction. In order to achieve these transcendental goals, the powers of the High Court under its writ jurisdiction are necessarily broad. They are conferred in aid of justice. The court has repeatedly held that no limitation can be placed on the powers of the High Court in exercise of its writ jurisdiction. Then a constitution bench of this court held that the nature of power exercised by the High Court under its writ jurisdiction is inherently dependent on the threat to the rule of law arising in the case before it. Then, Lord, paragraph 10 is quoted. Please come to the paragraph just after the quotation. The powers of the High Court in exercise of its writ jurisdiction cannot be circumscribed by strict legal principles so as to hobble the High Court in fulfilling its mandate to uphold the rule of law. While the powers of the High Court may exercise under its writ jurisdiction are not subject to strict legal principles, two clear principles emerge with respect to when a High Court's jurisdiction may be engaged. First, the decision of the High Court to entertain or not to entertain a particular action under its writ jurisdiction is fundamentally discretionary. Secondly, limitations placed on the court's decision to exercise or refuse to exercise its writ jurisdiction are self-imposed. It is well settled principle that the writ jurisdiction of a High Court cannot be completely excluded by statute. If a High Court is tasked with being the final recourse of upholding the rule of law within its territorial jurisdiction, it must necessarily have the power to examine any case before it and make a determination of whether or not it not its writ jurisdiction is engaged. Judicial review under 226 is an intrinsic feature of the basic structure of the Constitution. Then, Lord, various judgments are considered. Ultimately, if your lordships will come to paragraph 23 or 22 onwards. Paragraph 22. The mere existence of an alternate forum where the aggrieved party may secure release does not create a legal bar on a high court to exercise its writ jurisdiction. It's a factor to be taken into consideration by the High Court among several factors. Thus, the mere fact that the High Court at Madras is capable of granting adequate relief to the appellant does not create a legal bar on the Bombay High Court to exercising its writ jurisdiction in the present matter. Then this brings us to the question of Clause 21 itself creates a legal bar on the Bombay High Court's exercising its writ jurisdiction. As discussed above, the writ jurisdiction of the High Court is fundamentally discretionary. Even in exercise of an alternate adequate remedy is merely an additional factor to be taken into consideration by the High Court in deciding whether or not to exercise its writ jurisdiction. This is in marked contradiction to the jurisdiction of a civil court which is governed by statute. In exercising its discretion to entertain a particular case under 226, a High Court may take into consideration various factors, including the nature of injustice that is alleged by the petitioner, whether or not an alternative remedy exists, or whether the facts raise a question of constitutional interpretation. These factors are not exhaustive, and we do not propose to enumerate what factors should be or should not be taken into consideration. It is sufficient for the present purpose to say that High Court must take a holistic view of the facts as submitted in the writ petition and make a determination on the facts and circumstances of each unique case. Now, my lord, this is the view, and your lordships will finally see that, Lord, the Aligarh Muslim University's case is considered in paragraph 24.
Yes.
And then, Lord, ultimately, the 26 is, Lord, the conclusion, which says, in the present case, Bombay High Court has relied solely on clause 21 of the Constitution, that means bylaws, to hold that its own writ jurisdiction is ousted. The Bombay High Court has failed to examine the case holistically and make a considered determination as to whether or not it should, in its discretion, exercise its power under 226. The scrutiny to be applied to every writ petition under 226 is a crucial safeguard of the rule of law and the Constitution in the relevant territorial jurisdiction. It is not open to a High Court to abdicate this responsibility, etc.
Yes.
So, the first point is that this Madras High Court judgment, which has been cited, or even the subsequent, the Supreme Court judgment 2004, volume 9, the issue is being looked into from a different angle altogether.
Yes.
The contractual clause may be, binding on the civil courts, which are guided by statute. But here, the power flows from the Constitution, and the Supreme Court is of the view that there is no constraint, no restriction. Merely on the jurisdiction clause, the High Court's jurisdiction is not lost. Now, on this very issue, that uploading of the tender documents or receiving the communication through a system in Calcutta, whether it would confer a jurisdiction, I lost. And now I think that thankfully I lost, because this is the judgment by which I had taken the point, same point as my learned friend had taken.
MRT signals.
MRT signals. Kindly, have a look at this judgment. Please come to paragraph 17. Paragraph 17, page 5.
Yes.
It is reiterated by the respondents that the writ petition is not maintainable due to lack of territorial jurisdiction of this court, since the respondents have their offices in Madhya Pradesh. The work contemplated in the tender is to be done in state of Madhya Pradesh, and the documents were partially to be submitted physically at Jabalpur in Madhya Pradesh. Nothing has been shown by the petitioners to the effect that the petitioner's business would be affected in Kolkata, since the work was for Bhopal such and such, which is beyond the territorial jurisdiction of this court. Thus, the respondents argue that the writ petition ought to be dismissed on the ground of territorial jurisdiction. The issue, my lord, kindly take note of the first issue, which is relevant for our purpose, which says this court has territorial jurisdiction to entertain and decide the writ petition. Then, my lord, the decision on first issue starts from, my lord, paragraph 22. The terms of the tender are contained in RFP. Clause such and such stipulates that the contract shall be governed by the law for the time being in force in Republic of India. In case of any dispute and differences resulting in court cases between contractor and authority, the jurisdiction shall be the courts at Bhopal only. Clause 25(1) provides that the said agreement shall be construed and interpreted in accordance with the governed by the laws of India, and courts of at Bhopal shall have exclusive jurisdiction over the matters arising out of or relating to the agreement. Insofar as the first clause is concerned, no contract has been entered into as yet between the parties, since the matter is still at the tender evaluation stage. Thus, there is no scope of any dispute or differences between contractor and authority, hence clause so and so does not apply. Then clause 25(1) stipulates that the court at Bhopal shall have exclusive jurisdiction over matters arising of or relating to agreement. However, the present allegations pertain to the authorities having acted dehors the agreement itself. More importantly, the disputes envisaged therein are, as per the said clause, to be resolved in courts in Bhopal. However, the plenary powers conferred by Article 226 of the Constitution India are not circumscribed by territorial jurisdiction as contemplated in the statute, which drives power from the Constitution, including the Code of Civil Procedure. Then Maharashtra Chess Association is taken note of. Then, Lord, paragraph 28, there is another judgment, Pankaj Panwar. This is, Lord, our High Court's judgment, Justice Dipankar Datta's judgment. I have the judgment, I'll show you. Coordinate bench of this court, while considering the proposition that it has to be construed from the pleading as to whether the facts constitute essential, integral, or material facts so as to constitute a part of cause of action, held that when the impugned act of the respondent takes effect within the territorial jurisdiction of a particular high court, it may entertain the writ petition of the person aggrieved, notwithstanding the respondents have their offices or residences outside its territorial jurisdiction. When an order has been made by an authority or person at a place beyond the territorial limits of a particular high court, but the same is given effect to against the petitioner within the said high court's jurisdiction, at least a part of the cause of action arises when the impugned order is implemented. It was held that when an order becomes effective, only when it is communicated or served, the service of the order or receipt of a notice thereof would form a part of the cause of action for filing the writ petition. In the case under consideration by the learned single judge, a public notice which was published beyond the territorial jurisdiction was being considered. In such context, however, the learned single judge observed that to hold that service of an order or a notice on an addressee would never give rise to a cause of action or move the court within those territorial limits the orders notices received may not be a reasonably sound. Then Ashok Kumar Sabu, the division bench of this court, was considering the termination of a contract where there was an agreement of forum selection stipulating courts situated in state of Assam to have such jurisdiction. It was held by the division bench that it is impossible to think that the provisions under Article 226 can be contracted out by selecting one of the two competent forums, as there cannot be an estoppel as against a provision of constitutional law. The forum selection clause, it was held, does not envisage recognition and acceptance of contracting out of the provisions of Article 226 of the Constitution of India. Thus, merely by virtue of the forum selection clause in the tender document, it cannot be said that the jurisdiction of this court is ousted in the present case. Then, Lord, please come to paragraph 35. In the facts of the instant case, although the respondents have made out a strong case on territorial jurisdiction on the ground that the proposed work was under tender is to be done outside the jurisdiction of this court, certain other factors are also to be taken into consideration. The petitioners have pleaded in the writ petition that they have business throughout India and outside. Thus, the rejection of its bid in the subject tender would affect their business throughout India. Insofar as particular work is concerned and the working with the particular respondent in present case is concerned, undoubtedly the petitioner would be affected outside territorial jurisdiction of the court. However, the implication of rejection of a tender document are not confined to the particular tender inviting authority alone, but all similar contracts floated by authorities invariably contain a clause demanding disclosure as to whether there was any previous rejection of a participant's bid. This is not important. Please come to 37. In the present case, as in Pankaj Panwar, the effect of the rejection which took place in Madhya Pradesh was given when the petitioners received the communication from their office in Kolkata. Even if decision of rejection of the petitioner's bid was taken in Madhya Pradesh, which falls outside the jurisdiction of this court, the fact remains that the cause of action of the instant writ arose when the petitioner learnt about such rejection at Kolkata. Thus, at least a part of the cause of action arose within territorial jurisdiction of this court. The argument that some of the bid documents were to be submitted physically in Madhya Pradesh does not cut ice, since the primary tender document relating to technical and financial bids were to be submitted online, which the petitioners did from their Kolkata office. Hence, merely because the respondents have their offices outside jurisdiction of this court, it does not automatically signify that the territorial jurisdiction of this court under Article 226(2), read with Article 226(1) of the Constitution of India, is ousted. At least a part.
Yes.
Paragraph 39 is the concluding part. At least a part of the cause of action arose here as evident from the above discussion. Accordingly, the first issue is decided in favor of the petition. And Lord, this involved the railway authorities who are Lord, similar tender, had similar quoted similar tender, and there was no appeal from this order. I lost on the question of jurisdiction, but I ultimately succeeded on the merits. I was Lord representing one of the successful bidders there.
Yes.
Now, Lord, may I have the pleasure of taking your lordships through the facts of this case? No.
I'll decide on the maintainability.
Then, Lord, may I cite the other judgments on the jurisdictional issue?
Yes.
This is Lord, the other judgment on similar points.
What is here?
Paragraph 22. Onwards, if your lordships kindly see.
Yes.
As far as territorial jurisdiction is concerned, the petitioner has pleaded that the correspondence between the parties with regard to the present cause of action, which is also part of the bundle of facts which comprise the cause of action, took place in and from Kolkata. Moreover, the impugned certificate was received by the petitioner at Kolkata. The genesis of the issuance of the certificate was request of the petitioner, which was also made from Kolkata. That apart, the petitioner's work within territorial jurisdiction of this court shall also be adversely affected in the event the impugned performance certificate is used by the petitioner. Lastly, the petitioner's office is situated in Kolkata. Hence, this court has territorial jurisdiction within the contemplation of Article 226(2). Accordingly, it's allowed. An appeal was preferred against this order into the division bench. And this is the judgment of the division bench. This judgment was upheld. Kindly come to paragraph 14, which holds that the impugned order does not call for interference. It was Steel Authority, Lord, who had suffered the order judgment, and Lord, they had preferred the appeal. The appeal court affirmed the views. Now, Lord, factually, Lord, your lordship kindly sees, Lord, what are the facts, basic facts here, which, Lord, also gives the cause of action. Because, Lord, apart from the uploading of the documents, Lord, the result which was declared, declaring my client as L2, that was also, my lord, received, my lord, in Calcutta, because, my lord, it was uploaded and we downloaded it in Calcutta. Now, my lord, the issue is today that the main issue is that, my lord, in relaxation of the tender condition, the respondent number 6 has been declared as L1. This is the short point. And, my lord, if your lordship permits me to take your lordships through the petition, I can establish in 5 minutes that, my lord, what are the essential terms and conditions, and, my lord, how the respondent number 6 could be, my lord, declared as L1 because he has not complied with the essential terms and conditions.
I do not want to enter into the merit of the matter. I'll decide on the territorial jurisdiction.
Then, Lord, then let me, Lord, cite that Pankaj Panwar's judgment, which is taken note of by the.
Taken note of Justice
By,
Sabri.
I'll just hand up, Lord, the judgment. This is the Supreme Court's judgment. Oh, this is that Pankaj Panwar means our High Court single judge.
To decide on the point of maintainability first.
Kindly see paragraph 2 and 3, which is the preliminary objection taken, and 5. And, Lord, this judgment considers, Lord, all the judgments of the Supreme Court, including, Lord, this Utpal Bose's judgment, which my learned friend referred to. And, Lord, your lordships will find page, this is page 3. Your lordships will find that, Lord, all the judgments, State of Rajasthan, Oil and Natural Gas, National Textile Corporation, which my learned friend had cited, they had all been considered. And after considering that, the court, Lord, came to a finding. If your lordships, Lord, this entire judgment is only on maintainability, and paragraph 49, your lordships will find that the court overrules the preliminary objection. And paragraph 48, if your lordships kindly look at, it says to hold that service of an order or a notice on the addressee would never give rise to a cause of action to move the court within whose territorial limits the order notice is received may not be reasonably sound. If service of an order or a notice is an evidence of substance and or event which is material, essential or integral part of his list connected with the action which is impugned in the writ petition, there is no plausible reason as to why the same should not be construed as constituting material, essential or integral part of the cause of action. The plea of affectation of the right or interest by reason of such order notice being served, if based on a substantial fact of forming a part of the bundle of facts constituting the cause of action, would indeed be relevant for determination of the question as to whether the writ petition ought to be entertained or not. Here, the decision to withdraw the award and the plague from the petitioner was never communicated to him prior to the public notice being published in the print media. It is such publication, the only one secrets, etc. Now, Lord, here what happened, on the date the technical bid was open, the financial bid was also open. So, my lord, until such a time, the technical bid and financial bid both were open. My lord, I had no opportunity to know that, Lord, the respondent number 1, he doesn't have the credential. Lord, the credential is that there has to be a certificate of either of a completion work of the same value or substantial work.
See, I'm not getting into the merit of the matter. I'm only deciding the territorial jurisdiction.
Right. But, Lord,
as far as that is concerned, you can always challenge it wherever you want to challenge it. So,
Lord, the issue is today both the financial bid and the technical bid has been opened. So, Lord, if today, if your lordship, Lord, gives them time, Lord, the respondent number 6 will be given the work order.
I can only hear it and decide it.
Lord, because, Lord, bundle of facts will also have to be seen. That's why, Lord, I thought, Lord, I'll take your lordship through the.
You want to show something else from the facts, not on the merit of it, as far as the jurisdiction is concerned?
The jurisdiction, Lord, there are 2-3 things which I wanted to show to your lordship.
Yes, sir.
Lord, yes. Lord, if your lordships kindly come to. Lord, just give me 1 minute, just 1 minute. Lord, would your lordship kindly keep it as to be mentioned tomorrow, because I'm seeking instruction to withdraw the writ petition to move the Delhi High Court, because it's no point making your lordship work on the last day of the.
Don't make me work tomorrow.
No. Tomorrow, either your lordship, Lord,
I think that is a better option. Because unnecessarily, my mind.
Either your lordship gives us liberty, obviously, my lord. No, my lord would not dismiss the writ petition on the ground of merit. It's only jurisdiction. So if jurisdiction is the issue, your lordship dismisses it, I can still move. But I'm saying that instead of getting an judgment on the territorial jurisdiction, because Lord, we do all sorts of matters. So that is the reason why Mr. Chakravarti is very worried. So I just want your lordship keeps it as to be mentioned tomorrow. Let us see, Lord, we'll try to talk to client and come back tomorrow.
I think it's better you withdraw it, Mr. Chakravarti.
As to be mentioned in the morning. So.
To be mentioned. And don't ask me to pass an order on territorial jurisdiction tomorrow. I'm telling you, that will be very unfair.
No, my lord, I'll be there. I can assure your lordship, I'll be there.
If you want, I can work the entire night and I can give you an order tomorrow morning.
My lord did not have to work. We'll come back with a letter and withdraw it. My lord has expressed your lordship's mind, my lord. We don't want to take a chance. Just come back to me.
Inviting a judgment might have some.
It will have some bearing.
In Delhi High Court.
Then, Lord, again, appeal, etc. I was just advising that it's better to.
I also feel I'm no one to advise you, but I feel it's better. Thank you, Mr. Thank you, Mr. Chagar. Do you still want to burden me?
No. Tomorrow at 2 we mentioned, I'm with them.
Rest of the matters tomorrow. Let this matter be listed tomorrow. That's to be mentioned. Rest of the matters tomorrow. Anybody on the appellate side, you want to do something?
Your lordship should take a break. My lord is excited.